that's true, but it was also with an intent that when we took the break, I would make contact with the witness and ask him to text me that photograph because I could potentially authenticate it through other witnesses. He indicated that he would do so and then has ghosted me since. And I advised him that he's still under subpoena and that if he does not respond, he could potentially face contempt proceedings. So I may be asking the court's assistance with reaching out to him. It's not make or break for my case, but I do think it is curious that he assured me he'd send it to me, and I know he's received my text messages. So.
We didn't see it, but he said
those issues in the future, correct? Correct. You have an understanding?
Yes, Your Honor.
Everyone's clear on that?
Yes, ma'am.
I'll make a note of it. I'll trust you all. Okay? All right, so we have not received, and you would hopefully receive that item.
Yes.
All right, and I guess at some point, we're going to have to follow up on that perhaps. I don't know.
To the extent that the defense was the ones that called him, I don't know if maybe they're in better contact with him than the state. But I think that there is a reason for supplementing the record with what this item was, just so the court will.
So we have it in the record.
Correct.
Yes, that would be right.
we'll address it at the next break.
No problem.
Okay, that'll be fine. Okay, let's go ahead and do it. ladies and gentlemen. How are you all doing today? All right, everyone doing research to try to gather information about this case or independent investigation? How about seeing or heard anything in the news? Read anything in the newspapers? All right, very well. Thank you. We're ready to proceed now. Defense, you may call the next witness.
Your Honor, Dr. Diana Barrett, please.
Step forward, please. Raise your right hand and swear. All right, Dr. Please keep your voice loud.
Okay.
Clear, because the microphone is already and the voice is
Okay.
Good morning. State your name, please, for the record, and spell your last name.
Diana Barrett, B-A-R-R-A-T-T.
You are a medical doctor, is that correct?
Yes,
In what field of specialty?
neurology.
Can you tell us a little bit about your education leading up to becoming a medical doctor?
Yes, I went to University of Florida and I studied engineering, and then I went right from my bachelor's degree to medical school, also at University of Florida. And then I took a one-year leave and I obtained a master's degree from Harvard School of Public Health. Went back and finished medical school in 1996
Back at the University of Florida?
at the University of Florida, yes.
Anything before that relevant to your medical education?
Relevant to medical education? I went to Broward Community College for a year.
What about postgraduate?
Postgraduate, I did a year of general surgery at Charity Hospital in New Orleans, and then I did research for 2 years, and then I started my neurology training, which requires 1 year of internal medicine and then 3 years of neurology, and that was all done in New Orleans.
Which specific institution in New Orleans?
So at that time, it was 2 separate matching programs. So I did my first year at Tulane University and some of the same hospitals, and then my neurology training at LSU. So 1 year at Tulane for internal medicine, and then 3 years at LSU in New Orleans. They all had to take my class. Both of them are required courses.
Did you ever engage with the Care Resource Clinic?
Yes, I worked while I was at Florida International University. They didn't have a neurology clinic, so I did do work at Care Resource, which cares for patients with HIV and LGBTQ patients. And I also worked for a time at Camillus Health, which is connected to the homeless shelter, Camillus House.
So Camillus House is, can you tell us about the way compensation coming from Camillus House was associated?
I mean, they paid me a nominal amount of money to see patients there.
At some point you took maternity leave, is that right?
Yes.
It's a break in the...
Yeah, in 2008, I believe. I mean, I still had to keep working for a while after she was born, and then at some point I took a leave.
Prior to taking maternity leave, did you work with the neuroscience consultants at Baptist Health in South Florida?
Yes, I was at Baptist Maine in Kendall for 3 years, mostly in the hospital every day.
That was beginning in 2005.
Beginning in 2005, yes.
You were a staff neurologist there, is that correct?
Yeah, I was a neurologist. I did emergency room, a lot of emergency room inpatient, and some outpatient as well. Yes, throughout my career, I've been in contact with patients with traumatic brain injury. And where I trained, it was a level 1 trauma center, and then the Lee Health System was a level 2 trauma center, so there were a lot of brain injuries. A level 1 is just a higher level, and penetrating trauma, gunshot wounds would go there, severe car accidents, but some regions don't have an easily accessible level 1 trauma center. So
The Baptist does have.
I don't believe Baptist had one at the time. I'm not sure if they do now.
Louisiana State University had some work experience there.
Yeah, after residency, I stayed on faculty for a time, but then Hurricane Katrina hit, and I decided to come back to South Florida.
We have no hurricanes.
Right, well, you're better prepared.
Doctor, I see in your curriculum vitae that you've received some awards in your career. Can you tell us a little bit about any of those?
So I received through the American Board of Psychiatry and Neurology an award to conduct education research. And the goal was to train students and residents to discuss medical errors. So if a complication happened, they would go into a simulation, they would interact with a standardized patient or patients and, apologize for making the error and try to, disclose the error in a compassionate way. That was one of the projects.
Any other projects that you can think of for which you received awards?
I did get another award from the American Academy of Neurology to do research on simulations that I developed for training medical students.
Simulations with regard to treating patients, I presume?
Yes, And then there were other teaching awards. I got an innovation award as a clerkship director, teaching award from the American Academy of Neurology, teaching award for clerkship director, A.B. Baker teaching award through the American Academy of Neurology.
In addition to your private practice, do you continue to some degree in a teaching capacity?
I do. I've lectured at Florida Atlantic University for the residency program. I can't remember when. It might have been like over a year ago. And then I've given lectures at Nova. There's an allopathic medical school there now. I've given sleep lectures with them.
Can you tell the jury about any committee publications that you and explain what that means, actually, a committee publication.
Okay, so I was on a committee called, excuse me, the Neurology Milestones Committee, and we looked at the framework for assessing competency in neurology residents. And then we just looked at the data that had been accumulated over the last couple of years, and we revised it. And so every resident in neurology would be evaluated by their program based on the parameters that we established.
Is that still, are students still getting the benefit of that?
Well, they're residents.
Or residents, I'm sorry.
Right.
That's continuing.
Yeah, they're evaluated. I don't know if they find it beneficial, but they're evaluated by it every so often.
I see a publication here from September of 2015 entitled Increased Intracranial Pressure Team-Based Learning Project. Can you tell the jury about that?
Yeah, I developed that because we couldn't find a good resource for second-year medical students. The terminology is all new to them, and they don't have any clinical experience. So I had a team, and we wrote a publication. We wrote and published some course materials, and it's just an overview of head trauma and increased intracranial pressure. So it included things that they get tested on for their boards: epidural hematoma, subdural hematoma, subarachnoid hemorrhage, and then the initial information about how to treat those conditions.
Could you be a little bit better explanation of what subarachnoid? So I can't even say the hematomas that you were talking about, subarachnoid hematoma, and some other of these items that you mentioned.
Yeah, so an epidural hematoma could occur when someone hits their head really hard and they have a skull fracture, and then some blood forms right under the skull. A subdural hematoma is when a vein bleeds as opposed to an arterial bleed from an epidural hematoma. And then a subarachnoid is that occurs when an aneurysm ruptures.
What about memberships and activities in any professional societies that you've been involved in?
So I've been a member of the American Academy of Neurology probably for 20 years. I am a reviewer for some of their journals.
And you are a board certified neurologist, is that
Yes.
right? And for how long have you been a board certified neurologist?
I finished in 2003. Well, at that time we had to take a series of exams. Probably 2005 by the time I did my written and my oral boards. Probably 2005, I'm guessing.
And continuing through current times,
Yes.
right? What about editorial activities? Have you participated in writing any professional publications?
Yeah, so for editorial activities, I'm a peer reviewer for the American Academy of Neurology. They usually ask me to review abstracts that will be presented for the annual meeting. I review articles for some of their journals. Whenever it comes up, they make a request. And then, did you ask about something other than editorial activities?
Any, if you have participated in writing chapters of books of copies?
I have written book chapters on hyperbaric medicine. It's not really relevant to what we're discussing now.
I did not cover all of the activities, awards, and other professional associations with you here today, have I?
No, not all that. I mean, I'm a question writer for the neurology board exam.
Is there anything else that you would like to include that I may have missed or overlooked on your curriculum detail?
Just in form of the question, Your Honor.
Let's talk about your personal practice right now. You mentioned that you've been in private practice for 2 years. Is that right?
Yes.
Can you let the jury know a little bit about the nature of your practice currently?
So I don't take any insurance, and so on my website it says concierge neurology and sleep medicine physician. It's actually direct pay because the patients just pay me at the time they see me, and then I can give them a super bill. They can get reimbursed later for, if they can send it to their insurance and try to get reimbursed for my fees. And I see a wide range of neurology and sleep medicine patients. My youngest patient's probably 18. My oldest is in his 90s.
With regard to the term concierge, is the term concierge commonly used in the private practice of medical for the same purposes that you use?
Well, it usually means that there's a membership and patients pay per month. I had initially on my website direct pay, and nobody knew what that was. Everybody was asking me, what does that mean? And so I just changed it to concierge.
So the term concierge really focuses on how you receive payment from patients.
Injunction leading.
Could you just clarify, if any further clarification needs to be made, what the term concierge connotes?
So the reason that I changed it from direct pay is that people would call me all day long saying, do you take my insurance? So I just wanted to make it clear that I'm not on any insurance plans. And then, I got fewer calls asking if I take their insurance.
Dr. Baer, what is the difference between a consulting physician and a treating physician?
Okay, so if we're talking about legal matters?
Yes.
Okay. So a treating physician is responsible for the patient, and they are responsible for their well-being. They have to make appropriate recommendations, offer treatment, prescribe medications, recommend studies or consultations that might be needed, and take a global look at the patient. For a consultant hired as an expert witness, you're given a number of questions, maybe one question or a few questions that you need to answer, and you are not responsible for the patient. You don't necessarily give them any medical advice, and you don't treat the patient. You don't establish a patient-doctor relationship.
Have you, prior, other than being hired as a consultant in this case, let me ask you, have you been hired as a consultant to testify in this case?
Yes, I've been hired as an expert witness in this case.
Other than your consultant work in this case, doctor, have you ever been hired to be a consultant in any other legal case?
Yes, I've been consulted in other cases as an expert witness for brain injury cases or other types of neurological injuries.
Have you ever testified as an expert witness in a criminal case like this?
Judge objection? Unless you're pretrial.
Dr. Barrett, have you testified as an expert witness in other legal matters?
Yes,
Were those civil matters, criminal matters, or sprinkling of both?
civil.
And when testifying as an expert in civil matters, have you testified both as on the plaintiff's side and on the defense side?
I don't remember how much I testified, but I've been hired as by the plaintiff side and by the defendant side. How many of those went to deposition or trial, I don't recall offhand.
Do you recall when it was that you were retained to be a consultant in this case?
Yes, so to determine if Mr. Pino had a traumatic brain injury and to determine if it could cause amnesia and to determine if that could result in confabulation. Do you want me to define that term right now?
Yeah, we're going to talk about that in a
Okay.
few minutes. But,
And to determine if confabulation were present, what would the possible duration of that be?
and when was it that you were retained? to do so?
I believe it was October of last year.
And that was my firm retained you, is that
Yes.
right? You mentioned confabulation a few moments ago and traumatic brain injury. Can you explain to the jury what a concussion is?
Okay, so I should first go into the terminology because we use them interchangeably. So concussion. Can you hear me okay?
I can hear.
Okay. Concussion and TBI and traumatic brain injury, they're all terms that are used interchangeably. And so how that happens is there's an external force that causes the brain to shake back and forth inside the head. There could be an acceleration, deceleration injury. There could even be a rotational component to that, and it causes a large number of signs and symptoms.
Is there a method by which whether a traumatic brain injury has occurred is evaluated by physicians such as yourself? In other words, is there some criteria that is followed?
Yes, so the American Congress of Rehabilitation Medicine published a very nice, very clear, concise diagnostic criteria that most of us use to establish whether or not someone had a traumatic brain injury.
Is this a criteria that you have previously used prior to this case?
Yes.
Your Honor, if I could have Dr. Barrett step down, I've shared with the prosecutors in this case a demonstrative exhibit that we would like to share with the jury.
Is it going to be marked? Yes, you better have. Thank you.
Yeah, we can mark it. For the record, this is defense exhibit A37 for identification. Okay, Professor? Judge, we will see.
Push it back a little bit. No?
Carlos, there's a mirror.
There you go.
Okay, so it's a little gray.
Now, we need you to give this up if you will, please.
Okay, I'll try. So, as I mentioned, these are the diagnostic criteria from the American Congress of Rehabilitation Medicine. And there are a number of ways that you can confirm the diagnosis of traumatic brain injury. They gave us a few different pathways. So you could have just clinical signs, and that would be something that is observed at the scene of an injury. And then there's another pathway. Maybe they weren't witnessed, or maybe they didn't have any clinical signs that are older than that. They can have acute symptoms. So symptoms would be what the patient reports. So I have a headache, or I feel nauseated, or I feel dizzy. And if they only had acute symptoms without those signs, it has to be paired with clinical examination findings.
Does it say acute symptoms? What do you mean by acute symptoms?
Things that happen right away, more immediate symptoms, and it would be within 72 hours. If something happened after 72 hours, it might not be from the traumatic brain injury, these criteria wouldn't be applied.
So these are symptoms that you're looking for within the first 72 hours of a traumatic event
Yes.
and trauma event, is that right?
Yes. And then, if they don't have the clinical sign, because they only have one clinical sign, and if they don't have the symptoms plus the clinical examination findings, if there's a neuroimaging abnormality, so the CAT scan shows blood in the brain, or if the MRI shows damage to the brain that looks like it actually happened, then they would qualify as a traumatic brain injury. And then, I'll go into this more later, but cranial that's not accounted for by other factors, so maybe somebody is found unconscious and you don't know if they're not. It's like a fainting episode or a heart attack on the floor, so they are unconscious, but you don't know if
So let me direct you to right back up at the top, the criteria 1 box, mechanism of injury, in parentheses, plausible. What is being referred to as the mechanism of injury? What is meant by that?
Okay, so separate slide on that. So in traumatic brain injury, there's a transfer of mechanical energy to the brain. And these criteria give us examples of that. So the head is with an object, the head strikes an object. There could be maybe a flash injury where the person undergoes an acceleration and deceleration event, and the brain is shaking around inside the skull, but there's no contact with between the head and the other surface.
Is that like a whiplash situation?
Like a whiplash, yes.
So, for example, if someone is in a car with the seatbelt on, there should be a head-on collision, the person's head may not be in contact with any object, but just the forward acceleration because of the forward momentum of the vehicle. Is that right?
Objection to leading, Your Honor.
Apologize, that's correct.
Okay, so yes, in a whiplash injury, in a restrained passenger, there could be an acceleration, deceleration, injury. You don't know how many times the person's brain is shaking back and forth inside the skull, but just the contact inside the skull would cause traumatic brain injury.
How is the brain injured by making contact with the skull?
So we could directly damage the nerve cells, and then there are projections called axons. All the nerve cells are sending axons to other places in the brain to connect with other cells, or even to parts of the body to control your muscles. And the
axons can be stretched, and that can cause immediate extension, or they can actually be cut if you shear the injury.
So under normal circumstances, is the brain not in contact with the skull at any time?
So it's not banging into the skull. I mean, with younger babies, their brains are so big that fill their skulls. And as we get older, unfortunately, they get a little bit smaller every year. And so at some point, there is space, increasing space between the person's brain and the skull. And that can make you more vulnerable because there's more movement. And the veins can take over. Okay, and so the American Congress of Rehabilitation Medicine has also given us another way that the mechanism of injury occurs, or a blast injury or an explosion, where maybe the main part has hit the head, but there is still acceleration, deceleration, or deviation of the brain inside the skull. Okay, so if you have a plausible mechanism of injury, like if you have a plausible mechanism of injury, so there is a motor vehicle accident, a fall, or head trauma, then we go down this first arm, and you only need one clinical sign, and those clinical signs can be weakness, loss of consciousness, immediately after the injury, alteration of mental status, and something like that. There could be complete or partial amnesia. And there's another category of motor information, posture, and seizure.
Can you explain to us what, when you use the term amnesia, can you explain what that means more precisely?
Okay. So amnesia occurs in traumatic brain injury, and it's not always like it is in movies where they forget their name or they forget who they are or important details of their lives. They can forget things that happen immediately preceding the injury, and then things immediately after the injury. And sometimes they have trouble retrieving in their memory. And so retrograde amnesia would mean they can't remember what happened right before the injury. And that could be because they were recording all the events, you're paying attention to all the events, and then suddenly you get a head injury, you haven't had time to store those events in your memory. Right after the injury, your brain is damaged, and so you could have trouble storing memory, and you could also have trouble retrieving old memories.
What is the opposite of retrograde amnesia?
So there's retrograde amnesia, which means you forgot what happened right before the accident. And then I use the term anterograde, because you can't form new memories right after the accident. And then in this document, they use post-traumatic amnesia. And we do it synonymous with the injury. And then I'll just go back to the slide. So loss of consciousness is pretty straightforward. So you see somebody unconscious and unresponsive. Alteration of mental status. So alteration of mental status, you define it as someone who has reduced responsiveness, or maybe they're responding, but it's not appropriate to the stimuli. They're slow to respond, they could be agitated. And then if you give them a two-part command, like pick up your right hand and use it to touch your left ear, they can't put it together, they can't follow two-step commands. Or they could just be disoriented for some place and time. And then we went over the amnesia.
One moment, 2 slides. The reduced responsiveness. Can you tell us, expound on that a little bit more? So, for example, hypothetically, if someone is given a command, single command, example, move, get out, look here, look there. A failure to respond, the person who's listening to that, who has suffered a concussion, what would that be indicative of?
So that's one of the clinical signs that defines the diagnosis of traumatic brain injury. And you only need one of these of that list. So you only need one to determine that someone meets diagnostic criteria for traumatic brain injury. So either loss of consciousness, or alteration of mental status, or amnesia, or this other category, seizure or time.
So any one of those four items that is part of the criteria establishing traumatic brain injury, is that what you're saying?
Yes, you only need one of those. You need the mechanism of injury, and you need one of these signs. And then as long as there's not some other factor that this person is using, if the person had a seizure, and that's what you're requiring to determine for. As long as you don't have one of those, then you can be diagnosed for traumatic brain injury or concussion or deceive. Okay, so we kind of went over this already. If there's not another reason that the person was unconscious, then we need the diagnostic criteria for traumatic brain injury.
Dr. Barrett, you gave an explanation with regard to amnesia, both retrograde amnesia and anterograde amnesia. You mentioned the word confabulation. What is that exactly?
So confabulation, it's something that we teach in medical schools, mainly pertaining to certain types of dementia. So the person is really struggling with their memory, and they create a false memory. They have no intention of trying to deceive anybody, but they're confused, and they come up with something that's not correct.
Other than confabulation being a sign of dementia, is there any other association that confabulation might have with amnesia?
Well, so what I didn't say is that it usually we teach it in the context of a type of dementia called Wernicke-Korsakoff, but it's also in the literature pertaining to patients with Alzheimer's and other types of dementia, and it's also occurring in patients with traumatic brain injury. And so they are not collecting a lot of data on confabulation in
When you
general.
say they, who are you referring to?
Like people that are doing clinical trials and developing frameworks such as this, there isn't really data for them to look at in terms of confabulation. But the confabulation would be a byproduct or a result of amnesia, because the individual's really struggling with their memory, and then they generate a false memory.
Is there a connection between a concussion, traumatic brain injury, and confabulation?
Yeah, and that connection would be that they're struggling with their memory. They may have amnesia, they're having cognitive issues, and they say something that's just not correct.
When a person who is experiencing confabulation says something that is not correct, is the person being intentionally incorrect in what they're saying?
No, that's the definition of it, that they're filling in the gaps with a false memory without the intention of deceiving anybody.
And when you say false memory, would that include memories from actual previous events in a person's life?
It could be. They could be misplacing that memory in time, or they could be generating something that didn't, that has no relevance.
Is confabulation taught in medical school?
Yeah, I taught that lecture on it was pertaining to Wernicke-Korsakoff dementia.
You mentioned something about filling gaps when you were in the context of confabulation. Can you expound on that a bit more for the jury?
So in a person who's had a traumatic brain injury, they are not remembering things. So in order to remember something, you have to be recording it. So if you're unconscious, obviously you're not recording anything. But if you're awake, you are recording information. But you need to store that information, and then you need to be able to retrieve that information later. So in somebody that has amnesia, they might not have had the opportunity to store that information because the impact occurred right as they were recording that information. And then after the impact, they have brain damage, and so they might not be able to store those memories, or they might not be able to retrieve those memories.
In terms of confabulation, are older memories sometimes substituted for a current event?
It could be.
Have you experienced patients that are experiencing confabulation?
Yes, dementia patients, they forget things and then they fill in the gaps with other information.
When filling in gaps with other information, are those persons trying to be deceptive?
No. Sometimes they just don't remember. They used to bank with a certain institution and then they closed that account years ago, but they might not remember that they closed it, so they show up at the bank looking for their funds and the funds aren't available.
Is there any medical study or history which connects a person who has suffered a traumatic brain injury with confabulation?
There are studies on it. I just found a document recently, but I didn't have a chance to read the whole thing. But yeah, they do think more data should be collected on confabulation.
How soon after a person experiences a traumatic brain injury would they actually start to experience amnesia, for example, of the event?
I mean, it could be immediately upon awakening from the loss of consciousness, or it could be maybe they didn't lose consciousness. Maybe they just have difficulty with their memory. It could be immediately after the impact.
Same question with confabulation. A person suffers a traumatic brain injury. How soon after could confabulation enter the picture?
It could be immediate.
Is there and this was one of the questions that you were asked coming into this case as a consultant, but how long might a circumstance of confabulation persist?
It's indefinite.
Might it resolve itself on its own at some point?
It could.
And if it resolved it, how would it resolve itself on its own?
We don't really understand the mechanisms of confabulation. There are many theories about this circuit of the brain and that circuit of the brain, but there's nothing conclusive. So we don't know.
It's a poorly worded question on my part. What I was trying to ask, doctor, is that if a person is experiencing confabulation, a false memory, for example, is it the case that that person could then remember what reality was with regard to the incident?
They could. Over time, they might have a more accurate memory.
In regards to this case, can you explain or let the jury know what procedures, what methods you undertook to answer the questions that were asked of you in this case?
So if it's a case of traumatic brain injury, I always want three things. I want the accident report, usually generated by police, and I want the EMS records. And usually the police arrive first, so they might see something that is no longer a factor after EMS arrives. And then I want the EMS records, and then I want the emergency department records.
Now, all of the things that you just mentioned, the police report records, but particularly the EMS or the fire rescue records, is that right? EMS fire rescue?
Yes.
All right, so particularly with regard to the fire rescue records and the hospital records, is timing important for your evaluation as to whether someone had a traumatic brain injury or concussion?
Yes, because as I showed in the graphic, it matters what was seen at the scene of the event. So if there was loss of consciousness, if it happened, 5 days later, it really doesn't fall within those diagnostic criteria. But if the patient lost consciousness after the impact, or if the patient had amnesia directly after the impact, if these things were witnessed, then that confirms the diagnosis of traumatic brain injury.
Would records, either from fire rescue or hospital, records that, let's say, for example, let me back up. Let's say that a traumatic event, a boating accident, a car accident occurs on January 1st of any given year. Would medical records that were generated a year later be of any value to you in determining whether the individual suffered a concussion back on January 1st?
Probably not. It should be all in the records from the first 72 hours. I mean, there is one instance I can think of where maybe the patient didn't get brain imaging and they get it done much later, and it does show that there was trauma to the brain. It's a specific, maybe they have contusions of their frontal lobes or their temporal lobes on both sides. So something like that, if I couldn't make the diagnosis of traumatic brain injury from the records from the first 72 hours, it's possible that it could be diagnosed years later, but then you wouldn't know if it occurred right at that moment or occurred before or after.
With regard to the imaging that you would not know, could you explain that a little bit?
The imaging, yeah. I mean, how would you know the patient didn't have another traumatic brain injury after the first one or have a prior one?
So,
It'd be hard to date the image. You could just see that a traumatic brain injury happened at some point in time.
in this particular case, did you receive the records that you'd like to have generally, that you just explained a few moments ago, in order to make a determination as to whether Mr. Pino suffered a concussion or traumatic brain injury?
I did. I received the report from the Fish and Wildlife, and I received the EMS records from Fire Rescue, and I received a small amount of records from Baptist, Maine, and then I contacted the law firm because I could tell that all of the notes weren't in there, and then I was later sent a more complete set of records.
When you say the law firm, we're talking about my law firm,
Yes.
is that right? Once you had all of those records, were you able to make a determination as to whether Mr. Pino, number one, had a mechanical means by which a head trauma occurred, and whether there was enough evidence based on the records to establish a loss of consciousness or any of the other factors that we just talked about in the criteria?
Yes, I could see that he had a plausible mechanism of injury. He had a scalp hematoma, and it required 7 staples.
What does that mean, a scalp hematoma?
A scalp hematoma, so when he bumped his head, there was like blood accumulating under the surface of the skin, and there was a laceration, so they had to repair it with staples. I threw out the medical record, and it said that he was witnessed unconscious on the boat, and so that automatically made it very clear that he meets the diagnostic criteria for traumatic brain injury. He also had he had amnesia, retrograde and anterograde or post-traumatic amnesia, but that wasn't even necessary to make the diagnosis.
Let's talk with regard back to the diagnosis, and we'll get to amnesia in a moment. In addition to those records, were you aware of any eyewitness testimony as to whether Mr. Pino lost consciousness at any time?
I had a deposition transcript from a witness, and that said that he was seen unconscious.
Did you have an opportunity to note if Mr. Pino had injured his denture, his teeth in any way as a result of the accident?
Yes, I received some records that showed that he'd been to the dentist, and there were pictures of broken teeth.
So with regard to the pictures of broken teeth, assuming that the broken teeth did not predate the accident, is that significant in any way in your analysis?
Well, it's not needed to make a diagnosis of traumatic brain injury, but it fits the whole clinical picture.
How does it fit the whole clinical picture? Explain that.
Well, that there was trauma to the face and to the head.
You mentioned a moment ago amnesia. Did you make a determination as to whether amnesia was present as a result of the traumatic brain injury?
So I reviewed the videos of...
Which videos?
So he was interviewed by Fish and Wildlife after the accident, and there were a number of instances in which he said that he was very clear about what happened. And then he said, well, maybe that happened. Well, I'm not really sure, and then he would give the wrong answer. And this happened a number of times during his interview. So in one instance, he said, oh, I know exactly who was sitting behind me. And then he said, well, I'm pretty sure who was sitting behind me. And then he said the names of two girls. And
What were the names of the girls?
Coco and Andrea, I believe. And then, but in the report that came out from Fish and Wildlife, there were two different people sitting there.
Are you saying, Dr. Barrett, that the fact that Mr. Pino may have been mistaken about who was sitting in the back, that just because he made a mistake, that's evidence of amnesia?
Well, if it's just that one thing, maybe I wouldn't think of that. But he made other mistakes too. So he said, this is the size of my engines on my boat. And that turned out to be incorrect.
Do you recall what he said and how it is that he turned out to be incorrect?
He said it was, I'm not a boat owner, but he said he had two 225 engines. And then when the final report came out, it said that he had 300 engines on his boat. And then he made other errors also. They asked him, what did you see after you were first ejected? And he said, oh, I know exactly what I saw. And then he couldn't come up with what he saw. And then he said, it was really scary. And I'm having a problem recalling. And then he had another episode where he said, I'm very clear who was under the boat. And then he said it was Natty. He kept repeating, Natty was under the boat. And then later he said it was Lucy under the boat. And then the report came out that it was Luciana.
Are you aware whether or not the police report that you reviewed indicated, in fact, who was under the boat in this case? Is that right?
Yes.
And was it your determination, based on learning that information in the police report, that Mr. Pino was mistaken when he said it was Nati who was under the boat?
Yes, and it's not a mistake you would expect someone to make.
So all of these things together, is it the how do you characterize all of these mistakes and facts with regard to your diagnosis of amnesia?
Well, you look at the whole clinical picture. He did have the plausible mechanism of injury. He did have loss of consciousness, so he automatically meets the diagnosis for traumatic brain injury. And then when he wakes up, he makes... I could understand someone not remembering exactly who was sitting behind them, but he would remember what size engine he has. He would remember the name of the girl that was under the boat. And so these are mistakes that no one should make, and it fits with the clinical picture of amnesia.
And would you characterize that or categorize that as retrograde amnesia or anterograde?
So there were aspects of both. So if it were something that happened right before the injury, and he couldn't remember that, then that's retrograde amnesia. If it's something that happened after the impact, that would be anterograde or post-traumatic amnesia. And there were examples of both.
You actually met with Mr. Pino at some point in your office, is that right?
Yes.
Was it necessary for you to meet with Mr. Pino before you could reach your diagnosis of traumatic brain injury and amnesia?
No, I had what I needed from the medical records and the EMS records and the Fish and Wildlife report to make my diagnosis and come to my conclusion.
Was that
and
a-
I'm sorry, the videos also. I reviewed the videos.
And was that based on the criteria that you discussed earlier this morning?
Yes, I apply those with every traumatic brain injury case. I apply those same criteria, and then I determine if you can make a definite diagnosis of traumatic brain injury or not. And they're very easy to use.
Was there any benefit that you received as a consultant in this case in formulating your opinion by meeting with Mr. Pino?
So it wasn't necessary. Almost all of the traumatic brain injury cases I've been consulted on as an expert witness, they almost always want me to meet the patient and interview and examine the patient. But in general, I don't need that to determine if they had a traumatic brain injury, if I have records from that time.
Dr. Barrett, when we were talking about the criteria, you mentioned that one of the criteria you look for in determining TBI, traumatic brain injury, is the failure of the individual to be able to follow a two-part command. Is that right?
Yes.
The example you gave, correct me if I'm wrong, was that pick up your right arm and touch your ear or something to that effect.
Such your left ear.
Your left arm.
My left arm is right here. You also mentioned that a single command, failure to be able to follow a single command, which is more complex to the brain, following a single command or a double command?
Well, a two-step command is going to be more difficult.
Forgive me, a two-step command, right?
Yes.
A single-step command versus a two-step command.
Yes,
The two-step command is,
more difficult, yes.
if an individual, is there a measure on the degree of injury to the brain if a person cannot even follow a single command?
Well, that would be reduced responsiveness, yes.
Dr. Barrett, you charge my law firm a fee for your services, is that correct?
Yes,
Is this something that you normally do as a part of your consulting work?
yes.
And how much do you charge, or how much did you charge my law firm if you recall?
So I charge $600 per hour for the initial record review, $800 per hour for report writing, depositions, trial, and the total, I believe the total was $29,200.
That's as of today?
Those are the invoices that were submitted already, yes.
In charging our law firm $600 and $800 for review, $600 per hour, were those fees, were those hourly rates any different than what you charged any other law
No.
firm over the last several months?
No.
I don't have any further questions. Thank you, Doctor.
Good afternoon. Let's start with this. You're here because you were hired by George Pino's law firm to be a consultant in this case, correct?
Yes.
Do you see George Pino in this courtroom?
Yes.
Can you please point to and identify an article of clothing so our record will be clear who we're talking about?
He's wearing a light blue tie and a dark blue jacket.
Stipulate that.
Do you remember when you were first contacted by the defense firm about this case?
When I was first contacted,
Yes.
I don't remember the date I was first contacted, but I was retained, I believe, in October of 2025.
Okay, so that was September 20. So almost 3 years after this incident. That's fair to say, right?
Yes, the accident was on September 4th, 2022.
And you first met with him on February 2nd of 2026?
Yes,
And you met with him a second time on March 9th of 2026, correct?
yes.
Those are the only times that you've seen him, is that fair to say, aside from here
Other
in
than
court?
in the courtroom, yes,
Okay.
today.
And when you were retained in this case, you were asked to do only 3 things. 1, answer if he had a TBI, traumatic brain injury. 2, could it cause amnesia and false memories without the intent to deceive? And 3, how long those false memories could persist, correct?
It's not the exact wording, but it's mostly correct, yes.
And you constrained your work in this case to only answering those 3 questions. Isn't that true?
Yes,
And those questions came from the defense team, correct?
yes.
Now, regarding the issue of a traumatic brain injury, you would agree that there is a spectrum of traumatic brain injuries from, say, like a football player who gets knocked out on the field, but then is able to recover and go right back out and play again. Or you could wind up with a traumatic brain injury that is so severe that it permanently disables an individual. That's fair to say about TBIs, right?
I'm not sure if they're allowed to go right back into play, but I agree that there's a wide spectrum of presentations of traumatic brain injury.
We don't want to get into the concussion protocols of the NFL, but clearly we understand that if a player is knocked unconscious, once they are reviewed by another doctor that might be at the stadium, if they pass the clearance, they can go right back that same day, right?
I don't want to answer it. I don't do
Okay.
sports concussions on the field. I'm sorry.
But at the end of the day, whether your head gets hit on the football field or your head gets hit on a boat, your head is hit, right?
Yes, you're right to say.
And so the type of responses that you can have if you have a traumatic brain injury, it can vary depending on the severity of the injury, right?
It can depend on the severity of the injury. Some people are more vulnerable to injuries, and some people are much more resilient. So with the same injury, one person might get up and walk away and be fine, and another might be permanently disabled.
Okay. Now, you were asked you were asked to only look at these 3 questions that I've spoken with you about. At any point in your evaluation of this defendant, limited though it might be, do you have any evidence that he is suffering from dementia?
I did not diagnose him with dementia.
You're not a dentist, right?
No.
You got the opportunity to look at some photographs of the defendant's teeth, right?
Yes.
Now, they weren't broken, were they? They were chipped right at the top, right?
Pieces were broken off, but I'm not a dentist.
Right. Like, he didn't lose teeth, right?
The tips were broken off. I'm sorry if I'm using the wrong terminology, but
Hold on, let's get the actual image. It'll just take me a minute. I'm going to show you an exhibit. It's an evidence. It's case number 28. Excuse me, defense 28.
okay.
2B, sorry. 2B looks like an 8, sorry. 2B. These are the photographs of the defendant's teeth that you were shown, correct?
I believe so, yes.
I believe it's in evidence.
It is.
For a different number.
2B.
Yeah.
broken teeth. These are chipped teeth, right?
I'm sorry, to me, the pieces of the teeth are broken off, but pieces of the teeth are missing.
Showing you Defense Exhibit A, I'm showing you Defense Exhibit A35. Do you recognize this exhibit?
It's the Miami-Dade Fire Rescue. It's really hard for me to read, but yes, I believe elements of this are in my report.
And in fact, you listed in your report that you were given a Miami-Dade Fire Rescue report for the defendant from this incident, correct?
Yes, it has 4 pages.
And how many pages does Exhibit A35 have?
I count 5.
4 pages for the report, right? 1, 2, 3, 4, and then just a final.
Oh, this just says certified copy.
Right.
Okay.
So this is in fact the fire rescue report that you reviewed for this particular case, correct?
I believe so.
Okay, Your Honor, at this time I move Defense A35 into evidence as a state's exhibit.
No objection.
A35, March 4D, State's Exhibit 119.
Let's go over some of the information on that report.
Okay, which part? The font is
One,
really small.
let me get my copy so I can. So, first off, can you read for us what the narrative was of the fire rescue worker that treated George Pino on September 4th, 2022? On the first page in the middle.
Okay. Narrative. Patient was the driver of a boat that struck a piling by Caesars Creek. Several people stated that he was unconscious. He denies any neck or back pain. Assessment revealed a laceration to his right elbow, laceration to his head, and a hematoma to his right mid-axillary ribs.
Now, let's talk about what it says about where the defendant was taken to. The defendant in this case was taken to Baptist Hospital, wasn't he?
Disposition, hospital name, Baptist Hospital, Miami.
And now, Baptist Hospital, that, to your knowledge, is not a level 1 trauma center where he was brought, was it?
I don't believe it is, but I haven't looked them up recently.
On page 2 of this report, you'll see in the upper part of the page, there's a part that indicates that on September 4th, at 11:14, it's in military time, 23:14 and 0 hours, so about 11:14, under vitals. What does it say?
I-4 opens eyes spontaneously. Verbal 5, oriented, smiles, follows objects, interacts. Motor 6, obeys commands, appropriate response to stimulation. Total GCS 15.
GCS stands for Glasgow Coma Scale, doesn't it?
Yes, it does.
And it's an assessment of how alert and awake a patient might be, correct?
Yes.
And 15 is basically the highest level that you can have, isn't that true?
Yes.
Now, you indicated in your testimony that the defendant gave some answers to Lieutenant Thompson when he was questioned at Elliott Key that were inaccurate. Let's go through those inaccuracies that you talked about, that you noted in your report. Number one, you said that he was inaccurate in his description of who was behind him. Do you remember saying that?
Yes.
I'm going to show you an exhibit. It was marked into evidence as States 11. And it's a chart of, similar to looking like Mr. Pino's vessel, and there are seats labeled 2 and 3. Are there names next to those two individuals?
Yes, they're handwritten names.
Okay.
One says Sarah and one says Mia.
Right. So even if Mr. Pino didn't correctly remember the names of the girls who were seated behind him, you indicated that could be understandable, right?
If it were just one mistake, then
Okay, so if he was mistaken about that, though, it could be understandable because, number one, these girls were all dressed similarly. They were all in, like, string bikinis. Do you know that?
I don't know what they were all wearing.
And number two, they're behind him, so it's not like he's looking at them while he's operating the boat, hopefully, right?
He said that he turned to look behind him, but
Okay, but you indicated on your testimony on direct that it's understandable that he might have gotten those two girls' names incorrect, right?
yes.
Now, you also mentioned that he was wrong about stating what the horsepower of his two engines was, right? That FWC said they were 300 horsepower and that he had said they were 225 horsepower. You remember saying that?
Yes, I do.
Okay.
I'm sorry. Yes.
So the two things that he was asked about that happened prior to impact, one that he got wrong, one was about who was behind him, which we've already said, that's understandable. And the other thing that he got wrong about what happened prior to the impact was him saying that his engines were 225s rather than 300s, right?
Yes.
Now, you indicated there were two other things that he got wrong. One was that he couldn't remember exactly what happened right after the impact. So now we're talking about him remembering what happened in the moments or minutes after his vessel had slammed into a channel mark at almost 50 miles an hour, right?
I'm sorry, I don't know how fast he was going.
Okay. So wouldn't you agree that an impact at a high rate of speed might be different than an impact at a low rate of speed?
It could be, but the people have different vulnerabilities, so
But that information wasn't relevant to your determination of how to answer those three questions the defense gave you, right? The speed of the vessel?
no. The fact that he had loss of consciousness
Okay.
was important.
So let's go back to the four things that you had highlighted that he got wrong. The size of his engines and who was behind him. Those are things that he got wrong that happened pre-crash. But now the other two things that you highlighted, number one, he couldn't remember exactly what happened right after impact. And number two, he initially said that it was Nati that he recovered from under the boat. Those are things that happened post-impact. You would agree to that, right?
Yes.
And you would agree that in a written statement that he gave to Lieutenant Thompson, and when he spoke with Lieutenant Thompson, he actually did in fact note that it was Lucy that he had recovered. You're aware of that, right?
Well, in my report, it says that he starts out by saying it was very clear who was under the boat, and then he said Nati, Nati, Nati over and over again. And then later he said it was Lucy, and then the report came out that he removed Luciana from under the vessel.
I'm going to show you an exhibit that's in evidence. It's states number 102. Can you read this statement? Well, first off, let me ask you, would you consider a police officer asking a person to tell them what happened and then write down what happened? That's a two-step request from the officer, correct?
Well, it's a two-step if you ask them to do it all in a row, so you have to remember each step. So I might ask a patient, please pick up your right hand and use it to touch your left ear. And if they're confused, they might pick up their hand and then they forget what they're supposed to do, and they might later remember to touch the ear, not at all.
But you said that you watched the video of Lieutenant Thompson interacting with your client, correct?
He's not my client.
Pardon me, the defendant.
Yes.
So you then must have seen Lieutenant Thompson talking with the defendant seated at a picnic table and asking him about what happened and to write it down on a written statement. You remember that?
I think I do remember him writing something.
And so that would be kind of a two-step request. Tell me what happened and then write it down.
Well, if there's any bit of a delay afterwards, it wouldn't be a two-step command.
Do you remember there being a delay between Lieutenant Thompson saying, tell me what happened and then write it down?
Well, there would be a delay if he has to get out the paper and hand him the pen.
What if the paper is right in front of the defendant and the defendant has a pen in his hand?
I teach the neurological examination. That's not how we teach someone to do a two-step command. It's something that you say immediately. You say both commands in sequence immediately, and they have to remember them both.
Why don't you read along with me? Isn't this what the defendant wrote at the request of Lieutenant Thompson? Going back to ORC, Ocean Reef Club, the through channel, pass boat on left side of my boat, veered to the right to avoid big waves. Coming back into wave, I lost control of steering wheel as boat was going through the big waves. I was ejected from boat. In the back of the boat, I saw Mia and Sarah, my wife Ceci next to me, and the others in the front area of boat. I believe we were traveling at 40 to 45 RPMs. I have owned the boat since early 2020. I swam to Lucy and stayed until boat came. Then I stayed looking for others inside the boat. Did you see Mr.
Yes.
Pino writing that out for the lieutenant, right?
I believe I saw him writing something, but I couldn't see the text as he was writing it.
So of those four things that you highlighted were inaccurate answers. Who he recovered from under the boat, even though initially he said it was Nati, when he gave his written statement, he clarified it was in fact Lucy. Isn't that right?
He did clarify it, and I put it in my report that he clarified it later.
So now, of these four things that you have highlighted, who's behind him, the size of his engines, that he couldn't remember exactly what happened right after the impact, and that he didn't remember who was under the boat, we've pretty much explained away. He didn't see necessarily who was behind him. The girls were dressed similarly, right? You said that would be understandable if he got that wrong, correct?
I wouldn't be surprised if someone made one mistake on something that's not that important.
Right, but in your direct examination, you said to Mr. Shapiro it would be understandable if he got wrong who was behind him.
Yes, I did.
Okay. And his issue about the size of his engines being 225 versus 300, it's a pretty small detail. Would you agree?
The boat owners that I know, it's not a small detail.
Okay. The idea that he couldn't remember exactly what happened post-impact, that's not really surprising, is it?
Well, to me, it's evidence of amnesia.
Okay. But that would be amnesia post-crash, correct? Not pre-crash.
That's correct.
And then the fourth thing that you talked about, that he mistakenly indicated who was under the boat. In point of fact, although he initially said Nati, he corrected himself on that written statement, correct?
He did correct himself.
But you didn't note that in your report that you drafted in this case, did you?
It says in my report, Mr. Pino said that it was very clear who was under the boat. He said it was Nati Reed. He kept repeating the name Nati. Later, he said it was Lucy.
So when you were testifying, you indicated that he was wrong about who was under the boat, but you didn't clarify that he, in fact, corrected himself.
Objection, she did.
I thought I did.
Sure.
I'm sorry, I thought I did.
Now, would you agree that sometimes being involved in a stressful event, whether it's a boat crash or a car crash, in the immediate moments after something like that happens, would you agree that even if you don't have a traumatic brain injury, sometimes the details of what happened can be a little foggy because you're working through in your brain what just happened?
It might, or it might be the opposite. It might be something that you can't forget.
Now, other than the defendant not remembering who sat behind him, the horsepower of his engines, recalling exactly what he saw after being ejected from the boat, and stating that it was Nati, not Lucy, you're not sure that there were any other signs of amnesia. Isn't that fair to say?
I didn't see any other signs of amnesia.
Okay. Now, let's talk about the things that the defendant got right about what happened. You didn't note those things in your report, did you?
No, I didn't note every single thing, no.
So let's go over some of those things. You know that in his interview with Lieutenant Thompson, he said that when asked, hey, where is your wife? He indicated that he was asking about the condition of his wife and the girls that were on the boat. And he said to Lieutenant Thompson that Cammie was on a boat with his wife. Do you remember hearing that part of the conversation?
He might have said that. I wasn't paying attention to that part of it.
Now, if Cammie, whose given name is Camille Alvarez, came to this courtroom and testified that when she was rescued from the scene, she was on a boat with Lucy as well as Mrs. Pino, that would be a detail that the defendant gave to Lieutenant Thompson that was accurate, right?
If he got it correct, then it's accurate.
And you know that the defendant told Lieutenant Thompson that he had been a boater for a long time. That was accurate too, correct?
Yes.
You know that he told the police that he felt fine when he was speaking with Lieutenant Thompson.
I don't remember that exact comment.
But he certainly wasn't life-flighted from Elliott Key Harbor, was he?
No, he wasn't.
In fact, when Fire Rescue looked at him, they found him to be on a Glasgow coma scale of 15, as high as you can get, correct?
Yes.
And he was transported to a hospital that wasn't a level 1 trauma center. He was transported to Baptist that doesn't have the same capabilities, say, as like Ryder Trauma here over at Jackson Memorial. Fair to say?
I'm not sure what capabilities. I haven't worked at Baptist in a long time.
During his interview with Lieutenant Thompson, the defendant was able to point out that his daughter, known as Little Ceci, that she was also there on the island with him. Are you aware that he said that?
I don't remember that part of the video or the conversation.
So if, hypothetically, we had video footage where Little Ceci was pointed out on the island with the defendant, he would have been right about that fact, right?
Yes.
Mr. Pino told Lieutenant Thompson that the boating trip that he'd been on was part of a celebration for his daughter's birthday. Did you know that his daughter, Little Ceci, was going to be turning 18 a couple of days after this incident?
I knew that it was a birthday celebration.
So he got that fact right also, didn't he?
Apparently he did.
He also told Lieutenant Thompson that the other girls that were on his boat were his daughter's friends. Do you know that that's also accurate?
I don't remember that part of the video.
Okay. Well, if there was testimony even from the defendant's wife that the other girls that were on this boat were his daughter's friends, then Mr. Pino telling that to Lieutenant Thompson, he gave an accurate fact, didn't he?
Yes.
He knew that he told the police he'd owned that boat since 2020, right?
I believe so.
And in his written statement that he gave to the police that night, why don't you read this sentence that starts here, I have owned. What's that sentence?
I have owned the boat since early 2020.
So that was another detail that he got correct, right?
Yes.
He said that he was the only one who operated the vessel that day, didn't he?
I don't remember that part.
If his wife testified that her husband was the one that was operating the boat on that day, that would be another fact that he got accurate, correct?
Correct.
Do you remember him saying on the video to Lieutenant Thompson that he had checked the safety equipment on his vessel before leaving to go out on the water with the girls? Do you remember that?
I don't remember that part of the video.
If, in point of fact, on the video, Lieutenant Thompson asked him, did you check the safety equipment? And he indicated that, yes, I did check the safety equipment. If that was on that video, then the defendant saying that he had checked the safety equipment, that would be another accurate statement, correct?
Well, how do I know he checked it?
He knew at the time that he was interviewed that he was the owner of the vessel, correct?
Yes.
He knew that there were two girls seated in the back of the boat, correct?
Yes.
Now let's go over what he said about this crash. During his interview with Lieutenant Thompson, he told Lieutenant Thompson that they were getting to, quote, the last channel marker. Do you remember him saying that?
I think so.
And he says that they were, quote, on the last marker. You said you remember him saying that?
I think I do.
Do you know where this crash actually happened?
I'm not familiar with the waterways down there.
Okay. If there was testimony that this crash happened at a channel marker that was labeled channel marker 15, and that was the last channel marker that a southbound vessel would pass, he would have been right about that detail, right? Let me break it down. That's probably not a very well worded question. If there was testimony that the crash that the defendant was in happened at channel marker 15, number one, and if number two, channel marker 15 is the last channel marker for boats traveling south through the Cutter Bank Channel. If he said he was approaching the last marker, and the channel marker 15 was the last in that channel, he would have been accurate about that detail too, right?
Yes.
So I'm going to approach you now. I understand you might not be a boater, but this is State's Exhibit number 4. Do you see on State's Exhibit number 4 where it says Cutter Bank here?
Yes.
You see a series of red triangles and green squares here?
Yes.
And if this part here that I'm pointing to is north and this is south, what is the name of the last channel marker that we see in this exhibit?
Is this the channel marker, I think, the square?
What does it say here?
It says G and then 15 in quotations.
Okay, so you want to maybe let us sit down for a moment? So if the defendant's statement to the lieutenant is that the crash happened at the last channel marker, and if these green squares and red triangles are channel markers, what's the last channel marker for a boat that's going from the north to the south? What is it labeled as?
So I see a green square labeled as G, parentheses, 15, and parentheses.
Okay, so if that's the last channel marker, and if that's where the crash happened, then when the defendant was talking to Lieutenant Thompson, he was giving accurate reporting about where that crash occurred, wasn't he?
I think
Okay? Now, you're aware that the defendant was released from Baptist Hospital the very next day, correct?
Yes. I'm almost finished, Your Honor, if you could give me just a little bit of time. Thank you. Now, the report that you prepared for this case did not list all those things that we just went through that the defendant actually got right in his interview with Lieutenant Thompson. Did it? No. You only listed those 4 things that we've discussed that he got wrong. Correct. You were given an MRI that had been, or the results of an MRI examination that had been done of the defendant's brain from July 1st of 2025. You remember reviewing that? That MRI that you received, you didn't really take that into account at all in formulating your opinions in this case, did you? I don't think it was very helpful. Okay. And in point of fact, there was nothing about that MRI of the defendant's brain from July 1st of 2025 to indicate that there was any significant trauma to this man, correct? It's not specific for trauma, no. When you met with the defendant in February of this year, you never asked him if he sought treatment for the supposed brain fog that he had, did you? Well, I don't remember if I asked him that question specifically, but he did tell me that he was getting treatment and he was improving for his symptoms overall. Isn't it true that when you asked him about the treatment that he told you that he had had therapy and psychiatric medications, correct? Yes. Now, you said that your claim that the defendant could have suffered from amnesia comes largely from the videos that you witnessed of the defendant speaking with Lieutenant Thompson, right? It's not just from the videos. I look at the whole clinical picture, and he did have a significant trauma. He did have loss of consciousness. He meets diagnostic criteria for traumatic brain injury, and these mistakes that he made are consistent with amnesia. Right. That being said, though, there was no scientific test that you could administer to this defendant to prove that he had amnesia, was there? After the fact, no.
You did administer a test called the Montreal Cognitive Assessment Test, right?
Yes.
But that doesn't prove that he had amnesia, did it?
That cannot prove that he had amnesia at the time of the injury.
And in fact, the MRI for the defendant that was done on July 1st, that was normal for a man of his age, wasn't it?
He did have some white matter lesions in his brain, which is not surprising for someone who has a history of high cholesterol, untreated, and someone for that age.
Right. So it looked like a middle-aged man that might have high cholesterol, right?
It could be.
Now, you've indicated that thus far you've been paid $29,200 for your work in this case.
Yes.
That does not include the fee that you're going to charge for being here and testifying today in court, does it?
No, it doesn't.
You have no clinical tests that you can state to this jury that prove that the defendant had what I think you referred to in your report as a false memory without the intent to deceive, do you?
No, I can't test him for what happened back in 2022.
Now, it was your goal in evaluating the defendant to make a determination about really, what he remembered of the crash, correct?
Well, my goal was to answer the 3 questions.
Right. And part of that was to determine whether or not the defendant remembered what happened, right?
No, it was to look at the entirety of the medical record and determine the answers to those 3 questions.
You did not ask the defendant nor his wife that was with him when you met with him how the crash occurred, did you?
No,
You did not ask how the accident occurred, even though you were trying to find out what he remembered of the events surrounding the accident, right?
well, I had that from the medical record, and he was starting to get very anxious and stressed, and there's only so many questions you can ask a patient before they end up not being able to function on the cognitive testing.
So you never said to him, tell me how this crash happened?
No, I did not.
So you were evaluating his memory without asking him what he remembered, correct?
I was evaluating his memory on the day that he presented to my office.
Right. So you were evaluating his memory, but you didn't ask him what he remembered, did you?
No, I relied on the records, the medical records, and the Fish and Wildlife report and the EMS records.
So again, my question is, you were evaluating his memory, but you did not ask him what happened, did you?
Object.
I'm asking you if you can give me a straightforward answer. Did you ask yes or no?
Object. Argument.
I understand. But I'm sorry, let me ask the question again. You were evaluating the defendant's memory, but you did not ask him what he remembered of the crash, did you?
I did not ask him all of the details. I started asking him, how were you right before the crash and what happened after, and he started to get very anxious, and so I stopped with that.
Okay, nothing else.
Is post-traumatic stress disorder associated with head trauma?
It can be.
And when someone is suffering from post-traumatic stress disorder, do they exhibit anxious behavior?
Yes, they can, yes.
And the type of anxious behavior that Mr. Pino was experiencing in your office that day, would that be consistent with someone who was suffering with post-traumatic stress disorder?
It could be, or it could be anxiety disorder. I can't pinpoint exactly which diagnosis, but he was getting very upset.
Dr. Barrett, prosecutor pointed out that there were 3 mistakes Mr. Pino had 3 mistakes in his memory before the accident, and one mistake, I think she said, after the accident. Do you remember that question and answer, that question from the prosecutor a few minutes ago?
I remember she asked the questions, yes.
So lack of memory or mistaken memory before the accident is what we testified to as being retrograde amnesia.
Yes,
And you associated that with the traumatic brain injury, the concussion that Mr. Pino suffered as a result of the crash.
yes,
And so that mistaken memory prior to the crash is consistent with someone who has just suffered a
Objection,
concussion.
leading.
Is the mistake, are the pre-crash mistakes in memory consistent with concussion?
yes. So retrograde amnesia can occur, and it's one of the defining characteristics of traumatic brain injury.
As well as memories, is that true also with memories after the incident?
Post-traumatic amnesia, they define it as post-traumatic amnesia. I refer to it as anterograde amnesia. It's one of the clinical signs that are diagnostic of traumatic brain injury.
Here's the picture of the boat. Dr. Barrett, if Mr. Pino made additional mistakes in his memory to police officers on the night of or the afternoon of the crash, that would only underscore or support your opinion that he was suffering from amnesia. Is that fair to say?
Yes,
So hypothetically, if Mr. Pino told a police officer that the damage to his boat took place on the left side of his boat, when in fact it took place on the right side of his boat, that'd be a pretty big mistake in fact, wouldn't it?
it would be.
Showing you what is in evidence as State's Exhibit 68. Now, I know that you're not familiar with the way the boat in this case moves, are you?
I might have seen pictures of it.
Oh, where might you have seen that? Police report?
Yes,
So let me show you what State's Exhibit
I've seen
68.
this image.
All right. So State's Exhibit 68. That's the pretty simple, but if this is the front of the boat, do you agree?
Yes.
Is this the right side of the boat?
It's the right side of the
So
boat.
if Mr. Pino told the police officer that the damage occurred on the left side of the boat, that would be a mistake, wouldn't
Yes.
it? Would that be supportive of your opinion that that mistake in memory occurring after the accident is an example of anterograde amnesia? Did
It's
I get that right?
amnesia. It's amnesia. I don't know if that would be retrograde or anterograde. It's right at the moment of impact. I guess it could be. It could be retrograde because if he remembers what hit him and where he was.
One way or another, it's amnesia.
It's amnesia. I just don't know if it's retrograde or
And would-
post-traumatic.
And in your opinion, would that amnesia be related to his concussion that he suffered?
It fits the whole clinical picture, yes.
If Mr. Pino, another hypothetical, if Mr. Pino told the police officers that he was ejected from his boat in the crash, and that was a mistake, in fact, would that also be supportive of your opinion that Mr. Pino was suffering from traumatic brain injury, concussion,
Yes,
and amnesia?
yes.
And I'm going to refer you, Dr. Barrett, to State's Exhibit 102. This is the written statement made by Mr. Pino to the police officer that night. And would you read the sentence where I'm pointing?
I was ejected from the boat.
So this isn't, so in fact, that's exactly what Mr. Pino said. It was a mistake in his memory that he reduced to writing when he was asked to do so, right? Would that, is that a yes?
Yes.
Would that also be supportive of your opinion that Mr. Pino, even at that time, was suffering from concussion-related amnesia?
Yes.
And if Mr. Pino Dr. Barrett, does amnesia in a case like this make it impossible to recall all facts that occurred prior to the accident?
No, I mean, they would especially have difficulty with the events that occurred immediately before the accident.
Would amnesia after the accident require that a person not remember any of the facts that happened after the accident?
No, it could be partial amnesia. It doesn't have to be complete.
In your opinion, after evaluating the medical records and the other documents that you reviewed in this case, do you believe that Mr. Pino was suffering from amnesia because he did not remember some facts?
Yes, it's in the diagnostic criteria that we showed. There could be partial amnesia. Yes.
The criteria you're talking about that we reviewed earlier today, is
Yes.
that right? So that criteria, you're saying, only requires partial amnesia?
Right.
Refer you to the fire rescue report. You have it up there?
I don't have. Do I? Oh. I'm sorry.
Yeah, so let me Dr. Barrett, I want to refer you back to State's Exhibit 119. That is the fire rescue report. Is that correct?
Yes.
And on page 2 of that report, that Exhibit 119, the prosecutor asked you about the vital signs that were taken near the bottom of the page there. See that?
Yes. It's under vitals, but I don't consider those vital signs. But yes, I know what you mean.
Right. Well, the timestamp that vital sign was taken, well, let's talk about that. The timestamp was September 4th at 23:14 hours.
Yes.
You understand, are you aware of military time, what 23:14 equates to, for the time that the rest of us go by?
Yes.
That's 11:14 at night, correct? Is that correct?
Yes.
And at 11:14 at night, the fire rescue paramedic noted that Mr. Pino's eyes were open and gave a score of 4. And by the way, these scores are associated with something called a Glasgow coma scale. Is that right?
Yes.
That's what the prosecutor was asking you about?
Yes.
Can you tell the jury what is a Glasgow coma scale?
So it's a score that is used especially in relation to patients with trauma. And you can give them a numerical score, and one category is, do they open their eyes? So some people won't open their eyes. Some people will open their eyes. If you shake them or pinch them, they'll open their eyes only to very aggressive stimuli. Some people open their eyes spontaneously. And then the other another category that we look at is if they're oriented. So maybe if they're disoriented, they don't know what day it is, then they would score lower. But this is he was oriented, and this is obeys commands, and then his total score is 15.
15 is the highest degree of awareness under the Glasgow Coma scale. Is
On
right?
that scale, yes.
In other words, the person is, I'm a 15 right now.
You're a
I think
15
so.
right now, yes.
Well, I'm awake, kind of, and aware of what's going on. That's a 15.
Yes.
When Mr. Pino was unconscious on the deck of his boat, what would his Glasgow Coma scale be in the situation, roughly?
Well, it would be less than 15. We don't know because we didn't try to stimulate him. So in order to know for sure, you'd have to talk to him, touch him, maybe rub his chest to see if he wakes up. So we don't know, but it's definitely less than a 15. And then you would see if he moved also, if he opened his eyes, if he was able to talk.
If Mr. Pino had a Glasgow Coma scale of 15, as is noted by his paramedic, 14, does that mean that he did not suffer a traumatic brain injury?
No, it's consistent with traumatic brain injury, concussion.
One other thing about Mr. Pino's mistaken memory is that he said to the officer, as he pointed out a moment ago, he recalled him telling the officer that he was ejected from the police car against terror.
I believe that was said, that he was, that's in my report, that he said that he was ejected.
He said it in his written statement as well. Is that right? State Exhibit 119.
Yes, I believe so.
So if Mr. Pino did not even remember that he was on the deck of his boat, as opposed to having been ejected out into the water, that would be good evidence of amnesia. Is that right?
It's evidence, yeah, it's all evidence that fits into the picture.
Concussion-related amnesia.
Yes.
I have no further questions. Thank you.
Judge, there was a new issue that was addressed in that report.
By the way, I'm going to make inquiry of Mr. Pino at some point, probably after you finish this witness, as to whether or not he wishes to testify. So, imagining we've already had some conversations about that, but I'll give you a few moments to speak with him again. Thank you. All right, ladies and gentlemen, welcome back. We are ready to continue. And defense, your next witness.
Andrew Escalado.
Please step forward, face the group, and your name is sworn.
Do you swear affirm testimony about the case and the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
Thank you.
Good afternoon, Judge.
Good afternoon.
Mr. Mescalado, good afternoon.
Good afternoon.
I'll ask you to get that microphone closer to you, or you get closer to it. You testified in the court in this proceeding once before
Yes.
for a few minutes, I think it was last week?
Yes, I did.
Okay. And so I'd like to ask you some questions about your the limited subject matter of your testimony. You were asked some questions last week about interrogatories.
Yes.
Okay. First, let's remind the jury who you are and your profession.
Sure. My name is Andrew Mescalado. I'm a maritime attorney. I'm a partner at the law firm of Fertig and Gramling in Fort Lauderdale.
And what is the typical case that you handle at the law firm you've been with?
So we're a civil law firm. We don't deal with criminal matters like this. We handle marine-related civil litigation and transactional matters.
Okay. And for how many years have you been practicing in this area?
It will be 20 years this September.
And how did you come to be involved in the case of George and Cecilia Pino?
So approximately a week after the boating accident, my law firm was retained to defend George Pino by his vessel marine insurance company.
So who contacted you? Was it the insurance company?
Yes, as is typical, we would get a phone call or an email from the handling adjuster at the insurance company, and he would assign our firm to be counsel for Mr. and Mrs. Pino. The way it works is we're hired and paid by the insurance company, but our ethical obligations, our clients are actually the Pinos.
Okay. But the Pinos did not select you as their lawyer?
No.
And so was there insurance related to the vessel, the Robalo?
Yes. Mr. Pino had a marine insurance policy on the Robalo vessel with insurance limits of $300,000 for liability claims.
Okay. And what does that mean, $300,000 limit? What does that mean?
So, unfortunately, he had a maximum insurance coverage of $300,000 for this entire accident. There were some supplemental, there's coverage called MedPay, which pays for reimbursement of medical bills. So he had $5,000 in medical pay coverage for each person that was injured on the vessel, but the primary limit was the $300,000.
And if the amount of compensation or medical bills exceeds that, who's responsible for that?
Mr. Pino personally.
Okay. And were any civil claims, did the insurance company tell you there were civil claims being brought to the insurance company's attention?
Yes. After an accident like this, you would expect, obviously, person sustained injuries. We had a fatality. So you would expect claims to be brought. They either come to the insurance company or they're made directly to Mr. Pino, but everything would have gotten referred to my firm for investigation and handling.
Okay. And how many of the passengers brought civil claims in connection with this incident?
So to break it down, there would be what I would call represented claims. So parties that approached with lawyers writing letters and sending information. So there were 4 parties that were represented for civil claims. Those would have been Ms. Rodriguez, Ms. Aguilar, the Fernandez family, and the Puig family. And then there would have been other less formal claims. We were approached directly by some of the involved parents to provide compensation for out-of-pocket medical costs, health insurance deductibles. It was very important to Mr. Pino that we did everything we could to resolve the medical bills and compensate those people that were involved in the accident.
Now, ultimately, were all the civil claims resolved?
Yes, all civil claims arising out of the boating accident were resolved.
Okay. With respect to the civil claims associated with the Puigs, there were interrogatories that were propounded. I think that's the word we use in, is that right?
Yes, so the Puig family, through their attorneys, filed a lawsuit in Miami-Dade Circuit Court Civil. They filed legal claims against Mr. and Mrs. Pino, the Ocean Reef Fire Rescue Department, 2 of the paramedics, and the Sky Helicopter Company that was involved in evacuating Ms. Puig from the accident scene. So when a civil case begins in that manner, I talked about this last time, but each party, any party in the case, has the opportunity to do certain kinds of civil discovery. So the interrogatories you're asking about are written questions that are written by, for instance, the lawyers for the Puig family and sent to my firm, directed to the Pinos. The Puigs also sent interrogatories to Ocean Reef and to the paramedics and to the Sky Helicopter Company. So you're required to create answers to the interrogatories, which are answered under oath by the party within a period of 30 days unless you have an extension. And you can also object to questions if they have, legal objections.
And so both Mr. Pino and Mrs. Pino were obligated to respond to those interrogatories?
Yes, they each received a discrete set. One was directed to Mrs. Pino, one was directed to Mr. Pino. At the same time, we also received what's called a request for production of documents. They give you a list of paperwork and documents they're looking for, and you have to respond with those as well.
And what was your practice, or how did you comply with the obligation that came with receiving the interrogatories?
So typical practice, by this point in the litigation, we had already met with Mr. and Mrs. Pino. We had reviewed materials from the FWC, body cam footage, and other parts of their investigation. We'd also done some of our own investigation, interviewing witnesses, online research, different things. So the interrogatories...
Let's do it one at a time.
Yeah, okay.
So that's generally how you would do it?
Generally, and just, I guess, to put a finer point on it, myself or a lawyer at my firm would actually draft out the answers to the interrogatories. That's not something clients typically do.
And in this case, was it someone at your law firm or the Pinos themselves who actually drafted the responses to the interrogatories?
It was myself and an associate that works for me.
Okay. And what would have been the source of information you would rely upon to complete the interrogatories for Mr. Pino and Mrs. Pino?
So it would depend on the question, but generally it would be my firm's investigation into the accident, which would include information from Mr. and Mrs. Pino, but it would also come from other sources.
Okay. So let's take a look at the interrogatories that are in evidence. I'll start with Exhibit 12. This is the one for Mr. Pino. Judge, I'll approach with your permission. Do we have this on the screen by any chance? Do we have it in the...
Put it on the screen if you want.
Okay, if you could. We'll see if this works. Otherwise, have Carlos be prepared to help with that. Question number 5 says, describe in detail how the incident described in the complaint happened, including all actions taken by you to prevent the incident. Fair reading?
Yes.
Okay. And why don't you read the response that was typed in there?
It says, pursuant to Florida Rule of Civil Procedure 1.340C, Mr. Pino refers to his statements on the body cam to FWC investigator Thompson.
Now, I don't mean to do a law quiz, but maybe you could tell us what is Civil Procedure 1.340C?
Sure. So when you're responding to an interrogatory, sometimes the answer could be extremely long. So you're allowed to refer, instead of typing out the answer, you're allowed to refer to other records that the party sending you the questions would have equal access to. In this case, By this point, all parties in the case had access to Mr. Pino's interview with the FWC that appeared on body cam.
And so the answer to question number 5, who typed that in? Someone from your office?
Myself or someone from my office.
And Mr. Pino adopted it by signing at the end that it was true to the best of his knowledge?
Yes.
Okay. Let's take a look at State's Exhibit number 13. This would be Mrs. Pino's response to the interrogatories. Is question number 5 for Mrs. Pino identical to the question number 5 from Mr. Pino?
Yes.
And so we heard the response that was typed in for Mr. Pino. What was the response typed in for Mrs. Pino?
Sure. While returning to Ocean Reef, a vessel passed heading in the opposite direction. The vessel caused a wake, and then the accident occurred.
And from where did you obtain that information?
This information was obtained from Mr. Pino,
Okay.
as well as from him directly and from his statements to the FWC.
Okay. And so if they were obtained from Mr. Pino, why would they then be in the answers to Mrs. Pino's interrogatory?
So Mrs. Pino is obligated to answer these questions in a manner that's consistent with the position she's taking in the civil case. So it's common to adopt information from other witnesses that you know to be truthful.
Okay. So is it appropriate for Mrs. Pino's answers to the interrogatories to rely upon the recollection of her husband from the incident?
Objection leading, Your Honor.
Okay. I'll try this way. If Mrs. Pino hadn't actually observed the accident, how would she properly answer that question?
It would be prepared for her with information that existed from other sources.
Okay. And so did you approve her answering question number 5 by relying upon the information from the investigation and what her husband had reported?
Yes, otherwise it wouldn't have been in the interrogatory.
Okay. Let's take a look at question number 6, back to Mr. Pino. If you could read that to the jury and then stop a second.
Sure. Number 6 is describe in detail each act or omission on the part of any party to the lawsuit that you contend constituted negligence that was contributing legal cause of the incident in question.
And what was Mr. Pino's response in his interrogatory?
The wake of the unidentified vessel headed northbound was a contributing legal cause of the incident in question.
Okay. And from where did you obtain that information?
This information was obtained either directly from Mr. Pino or through review of his statements made to the FWC.
And did you understand that that recollection reported in there was the recollection Mr. Pino had reported immediately after the accident?
Yes, absolutely.
And you saw it with your own eyes from the evidence?
Yeah, I certainly watched all the body cam interview.
Now let's compare that to Mrs. Pino's answer to number 6. If you could read number 6, or is it exactly the same?
So the question and the answer are exactly the same. This is in part a legal question about the Pino's position in the lawsuit. It's not a purely factual question. They're asking about negligence and other defenses and claims that are in the case. So this is a mixed question of law and fact. So of course, an attorney would prepare this for their client.
Let's go to number 8 for Mr. Pino.
So I can read it?
Please do.
Sure. Do you contend any person or entity other than you is or may be liable in whole or in part for the claims asserted against you in this lawsuit? If so, state the full name and address of each such person or entity, the legal basis for your contention, the facts or evidence upon which your contention is based, and whether or not you have notified each such person of your contention.
And what was the answer to that question in Mr. Pino's response to the interrogatory?
The answer is yes. They have a contention. The unidentified vessel headed northbound in rem and its operator. The unidentified vessel headed northbound created a wake that caused or contributed to the accident.
Okay. Is that the same question and same answer given in Mrs. Pino's interrogatory?
Yes.
Identical?
Yes. And again, this is a mixed question of law and fact. This is a Florida standard interrogatory that the Supreme Court has drafted for civil litigation. The purpose of this is to make you disclose other people that you believe were involved in the accident. So all parties can know about this at the inception of the case, not find out much later.
So explain that in terms of giving notice to the opposing party in a litigation. What do you mean by that?
So there's a complaint which the plaintiff files that's answered by the defendant, but it's very basic information. So the purpose of initial paper discovery like this is to kind of flesh out what claims for the plaintiff or defenses that a defendant may bring in a case. So, for instance, the Puig's attorneys can fashion their discovery plan, what witnesses they want to depose, and that sort of thing. So these are required to be answered such that, as a defendant, the Pinos would be giving fair notice to the plaintiffs of their position with regard to cause of the accident or contributing cause.
And if Mr. Pino's recollection at that time was that there was another boat that may have contributed to him losing control of the vessel, if that's his recollection, was he obligated to notify or to respond to that in the questions propounded in the interrogatories?
Oh, absolutely. That's the purpose of these questions.
Okay. Let's see if there's any others. I think that's it. Can you take that back from you?
Sure.
At the end of the interrogatories, it is signed by each of the parties, Mr. Pino and Mrs. Pino, respectively.
Correct.
And there's a declaration that each makes that it's under penalty of perjury under the laws of the United States of America that the foregoing interrogatories are true and correct to the best of my knowledge on a particular date.
Yes.
And do you recall these interrogatories were signed in October of 2023?
Yes.
And even what happens, well, let me take that back. Mr. Pino was obligated to give his best recollection at that moment in time?
Yes, on the variety of issues in the interrogatories. There's legal questions, factual questions, a mix of different things for both liability and damages.
And Mrs. Pino, could she rely upon his recollection in responding to the interrogatories propounded upon her?
Absolutely.
If I could just have a moment. Judge, those are all the questions I have at this time.
Thank you. Mr. Mescalado, good afternoon again.
Good afternoon.
You indicated that the answers that you just read now for us are a question of mixed law and fact, right?
Some of them.
Okay, and so like questions about how did the crash occur, is that one of the questions that you would say is a mixed question of law and fact?
I'd have to look at which question you're talking
Sure.
about. I don't have them committed to memory.
So I'm going to show you State's Exhibit 12, which is an evidence, and this is the interrogatory that was entered on behalf of the defendant, in this case, George Pino, who is that man there in the light blue tie, right?
Yes.
For the record, identifying the defendant. There was a question that was asked, number 5, describe in detail how the incident described in the complaint, meaning, of course, the crash, happened, including all actions taken by you to prevent the incident. And what he says to answer that question basically not to put it in legalese, but like maybe everyday languages, what I said to Lieutenant Thompson, yeah, that's how the incident happened. Is that fair, accurate?
Yeah, that's what it says.
Okay. And is that what you would consider a mixed question of law and fact, or is that just a question of fact? How did this happen?
No, that would be a question of fact.
Okay. And then number 6, describe in detail each act or omission on the part of any party to this lawsuit that you contend constituted negligence that was a contributing legal cause of the incident in question. The wake of the unidentified vessel heading northbound was a contributing legal cause of the incident in question. That's asking for facts too, right?
That's a mixed question of law and fact.
Okay.
It's asking for contentions concerning negligence and various other points
So,
there.
so the answer is saying, I'm not necessarily the one at fault. This other vessel was the one at fault.
No, that's not what it's saying.
It's saying that constituted negligence, right? So the other vessel was the negligent vessel?
No, it's saying negligence is, it's different than criminal law. Many people describe it like a pie. 100% of the fault for an accident gets divided between the participants. That interrogatory is simply saying that the unidentified vessel bears some, we contended that the unidentified vessel bears some percentage of the fault for the accident.
Right, but if there was no other vessel, then this would be an inaccurate statement, correct?
I don't believe it would be inaccurate.
If there was no other vessel that contributed to the cause of this crash, then saying the wake of the unidentified vessel heading northbound was a contributing legal cause, that would be an inaccurate statement, correct?
That's Mr. Pino's recollection.
Well, that's what he told you was his recollection.
Correct.
Because you obviously would not want to put into a court file a pleading that was, from your vantage point, untruthful, right? You're an officer of the court.
Correct.
And so you have obligations when you file a document that what you're filing in good faith you believe to be accurate.
Yes.
And you thought in good faith that you could trust that what your client was telling you was truthful, right?
Yes.
Now, if an interrogatory is posed to a party to a lawsuit, hey, how did X happen? If that party does not know how something happened, that party can answer, I don't know the answer to that question, can't they?
They could.
And so when Cecilia Pino was asked about how the crash happened, she could have answered by saying, I don't know because I wasn't watching when the crash happened. She could have answered that, correct?
She could have.
But she didn't, did she?
No.
Now, you indicated that Mr. Pino wanted to do everything he could to resolve the claims, right?
Yes.
Okay, but that's not really true, is it?
I would disagree with you.
Because isn't it true that you wound up filing a pleading on March 15th, 2023, trying to limit his liability for his actions in this boat crash? Didn't you?
The federal court action?
Yes.
Yes.
In fact, may I see this? Oh, thank you. Record I'm showing counsel states 5-1.
So, Judge, may we approach on the exhibit?
All right, counsel, you can proceed.
Thank you. So, Mr. Mescalato, in point of fact, on March 15th of 2023, you filed on behalf of George Pino a petition for exoneration from or limitation of liability, didn't you?
I'd have to look at the date, but
For the record, I'm showing the witness states 5Y for identification.
yes, this is a petition for exoneration from or limitation of liability.
And who is the petitioner seeking exoneration from liability?
Well, it's exoneration or limitation. We wouldn't be seeking exoneration in this case, but to answer your question, it's Mr. Pino.
Right. It's not the insurance company, is it? The petitioner is George I. Pino, hereinafter referred to as the petitioner, correct?
Correct. In Florida, insurance companies are not parties in cases like this.
And so within that document, the defendant was seeking to limit what kind of liability he might have for his responsibility in this crash, correct?
Yes.
And in that petition, he gave a series of facts about what happened in the crash, didn't he?
The petition is not signed under oath, if that's what you're getting at.
Oh, so you don't have to be truthful in a court pleading if you're not signing it under oath?
You're talking about Mr. Pino.
Yes.
Mr. Pino didn't draft that document.
Understood, but you weren't there when the crash happened, were you?
Of course not.
Right. And so really the only source of information for how the crash happened was Mr. Pino or the people that were on his vessel, correct?
We also did investigation, but yes, the primary source would have been Mr. Pino and the people on his vessel.
And so the information was that there was, at about 6:30 p.m., that his vessel was subjected to a large wake thrown by a large center console or sport fish type vessel heading northeast on the intercoastal waterway, while his boat and the other one were going through the channel in the vicinity of navigational marker 15, correct? You remember that?
Yes, if that's what it says.
And that in that area, it amplified the size of the wake of this other vessel, correct? That was the information that you were given to put into this pleading.
Yes.
And that the vessel left the scene and to date has not been identified, correct?
That's an accurate statement.
That's what he said, right?
It's an accurate statement. We did not identify the vessel.
What if there was no vessel? Then of course you didn't identify it, right?
Presumably.
Okay. You also were given information from your client that the other vessel that his vessel began to turn unexpectedly on its own and put itself on a course roughly heading toward navigational marker 15. That was the information that was provided to you by the defendant, correct?
Yes.
Also that he attempted to steer and correct course but was unable to prevent an collision with navigational marker 15. That also is information given to you by the defendant.
Yes.
And this information was given to you while the defendant was trying to limit the liability that he would have for the damages that he caused to other people in that crash, correct?
Yes.
Additionally, again, you indicated that Mr. Pino wanted to do everything to resolve the claims, correct? Now, right?
Yes.
Now, the interrogatories that we were talking about, those were signed on October the 19th of 2023, right?
Correct.
Now, in addition to having filed in March of 2023 a pleading to try to limit his liability, you also then on August 14th of 2023, you filed a motion to try to get the lawsuit dismissed, didn't you?
We filed a motion to dismiss.
So the answer to my question was yes, right?
Well, the purpose of that motion was never to have the Puig's entire lawsuit dismissed. We were taking legal issue with certain claims that were brought against Mr. Pino and Mrs. Pino. Legal arguments about the viability of the claims. The purpose of a motion to dismiss is not wholly to knock out a whole case. It's also if you have issues with the claims that are being brought. We believe certain claims were legally insufficient. We filed a motion to dismiss. There was hearing before the judge, and it was granted in part and denied in part. So we received some relief, not all we asked for, and the lawsuit continued.
Right, but that certainly is not necessarily indicative of a person who's trying to do everything that he can to resolve the claims. That's a person who's trying to limit what claims he has to have.
No, by this point, the three claims that I mentioned before had already been settled or resolved, and we were litigating with the Puig family. In that situation, they brought a claim that could not be resolved at that time. And so we were required to do certain things to defend Mr. and Mrs. Pino's rights.
No, of
while
course.
working to try to resolve the Puig claim, which is what ultimately happened.
Right, but it certainly hadn't happened. There was not an agreement by the defendant in this case to allow what the Puigs were seeking to go forward. At that point, he was saying, no, I'm not willing to do that which the Puigs are asking for. Isn't that true?
No, that's not accurate.
So he was ready to settle
So
as of August of 2023.
while the Puig claim had been mediated prior to them filing a lawsuit, so Mr. Pino and his wife attempted to resolve that case before litigation was ever filed. They continued to attempt to resolve that case throughout the entirety of the litigation. And it was only when we got to a certain point that a resolution was reached. So you simply have to do certain things to answer pleadings, respond to complaints, respond to discovery. All the while, efforts were underway behind the scenes to try to resolve these claims.
Right, so mediation was attempted first. That was unsuccessful, and there being your client being, or your then client being willing to do everything he could to resolve the claims. And then after that was unsuccessful, then a lawsuit was filed against him,
So there were,
correct?
yes, and then there were multiple other mediations between the Pinos, the Puigs, and all the other involved parties while the case was progressing.
Right, and the other involved parties had nothing to do with George Pino. They had to do with other entities like, Ocean Reef Volunteer Fire Department, things of that nature, correct?
Yes, the Puigs brought claims related to the treatment their daughter received after the accident.
Right, but I'm not really focusing on those claims. I'm asking you about the claim between the Puig family and George and Cecilia Pino. So to the extent that during that litigation, a motion to dismiss was filed, that's not necessarily indicative of a man who's trying to do everything he can to resolve the claims, is it?
I would disagree with you.
Okay. Now, in order to file that claim, once again, you had to rely on information from your client at the time, George Pino, right?
In part.
And so, because his wife Cecilia has said that she didn't see the crash, really the only source of information that you had about how the crash happened was pretty much from your client, right?
Not exclusively. We had interviewed other persons aboard the vessel. I had spoken with the FWC investigators. I had reviewed what reports were available from the FWC. We had access to the body cam footage, so there was a lot of sources for information in addition to Mr. Pino.
Sure, but in terms of how the crash itself happened, body-worn camera couldn't tell you, could it?
Well, the investigators certainly had their theories about how the crash happened, which were relayed to me.
Right, but again, body-worn camera footage doesn't tell you how the crash happened because the body-worn camera wasn't turned on until after the crash had happened.
Well, body-worn camera footage captured interviews with Mr. Pino and many other people that were involved in the accident, so it did provide information.
Okay, but in terms of the actual conduct of the operator of that vessel, are you saying that the girls that were on the vessel were able to give information about how George Pino navigated the boat?
There was some information received from the girls about his navigation of the boat on that return trip, yes.
At the time of the crash?
Not at the time of the crash.
Right, not at the time of the crash. So you really didn't get any information about what was happening with that vessel at the time of the crash from any of the girls because they were not paying attention to how he was navigating, were they?
Correct.
Okay, so now, in terms of explaining how the crash happened, George Pino told you that his vessel was subjected to a large wake thrown by a large center console or sport-type fish vessel, correct?
Yes, we've already talked about that.
Yeah, I know. We talked about what he said and what you put in a pleading in March of 2023. I'm not asking about a pleading that was filed in August of 2023, about 5 months afterwards, correct?
Yes?
He also told you, once again for this pleading, that the boats were transiting the Cutter Bank shallows in the vicinity of navigational marker 15, correct?
That sounds like it came from the FWC report.
Okay. Are you aware that the defendant talked about the fact that he alighted with the last channel marker in the Cutter Bank channel?
I don't know that I remember that level of detail right now. It's been a couple of years since
Sure.
I've been involved. but-
Sure. If it were the case that the defendant gave a statement that he crashed into the last channel marker in that channel, and if the last channel marker in that channel was channel marker 15, if those facts were true, then if your client is telling you that the crash happened in the vicinity of navigational marker 15, then what he said to the police would be accurate, correct?
I'm not sure I'm following you.
Sure. Let me break it down. Sorry, I should ask the question better. Let's suppose that your client, former client, George Pino, told the police the night of this crash that the crash happened at the last marker. Okay? And let's suppose that the last marker of the Cutter Bank channel is navigational marker 15. If he said to the police that the last navigational marker was where the crash happened, and if the last channel marker in that channel would be channel marker 15, then the information that he gave to you about where the crash happened would be accurate, correct?
If I'm following you, it sounds accurate.
Okay. He told you that he adjusted course to meet the wake and impacted the wake, right?
Yes.
He talked about trying to attempt to steer and correct course, but could not prevent the collision with navigational marker 15, correct?
Correct.
Now, probably a lot of people have heard of the so-called attorney-client privilege, right? You've heard of it.
I definitely have.
Okay. And the idea behind the attorney-client privilege is that, for the most part, what a client tells his lawyer is going to be kept confidential unless under certain extenuating circumstances. Fair to say?
Yes.
And one of those exceptions that can lead to the attorney-client privilege not being applicable is if the client waives that right, meaning gives you authorization to divulge this information to others, correct?
Generally, yes.
And so in order to file those pleadings, the motion for limitation of liability, the motion to dismiss, as well as the information in the interrogatories, George Pino had to have given you authorization to release that information, correct? At least the information he gave to you.
I don't really see statements in a pleading requiring a specific waiver from Mr. Pino to draft a motion to dismiss, for instance.
What I'm getting at is that you didn't violate any kind of ethical or bar rule by sharing the information you had gotten from the defendant, in this case, in those pleadings, correct?
No, of course not.
Thank you. Nothing else.
Yes, sir. Mr. Mescalato, the conversation you've been having with the prosecutor relates to the civil claims that were being brought by the passengers, correct? And in particular, the Puig family.
Yes.
Okay. And so with regard to the Puig family, that was the one claim that was litigated, correct?
Yes. The other claims were all settled prior to a lawsuit being filed.
So no lawsuit filed in the other three claims. Those were settled pretty quickly after the accident, right?
Within a period of months, yes.
Okay. The Puig family, you tried to mediate, or you told us that there was mediation efforts, right?
Correct.
Now, the insurance was only $300,000 for this accident, right?
Yes.
And the claims being asserted by the Puigs and others well exceeded $300,000.
Many millions of dollars were claimed.
Okay. And by the time, well, there were three other families, the Fernandez families and two others, that was resolved. That would have, without getting into the exact numbers, money was paid over to those families that was no longer available to the Puig family, correct?
Correct. Mr. Pino paid out of his savings to resolve those claims.
The Puig family had claims that they were filing not only against Mr. Pino, but also Mrs. Pino.
Correct.
She was not the operator of the vessel, was she?
No, she was not.
And she still was being sued in connection with the claims brought by the Puig family.
Yes, they had a different theory of liability against Mrs. Pino.
Okay. And you were representing both Mr. Pino and Mrs. Pino.
Yes.
Okay. And the theory of liability against Mrs. Pino, who was not the operator of the vessel, and was she the owner of the vessel?
She was not.
Okay. Were you, as part of this course of civil litigation, bringing to the court's attention whatever, I say, motions or legal issues with regard to a theory of trying to impose liability on Mrs. Pino?
Objection, this is beyond the scope of cross.
I'll allow it, but
Will the court allow a recross then?
question or two, that's it.
I couldn't hear you, Joe.
Question or two, that's it.
Okay. Well,
I'm sorry, could you repeat?
yeah, the prosecutor asked you about a petition for exoneration and limitation of liability, right?
Correct.
And explain to the jury what that is.
So, as a vessel owner involved in a casualty of any type, really, this type of accident, a fire, anything that can happen on a boat, they have a right under federal maritime law to file this petition for exoneration from or limitation of liability. It's a type of lawsuit that's used in a situation where you're expecting multiple claims, because it requires the claims to come into a federal court proceeding rather than having to defend multiple different lawsuits in state court. Like if each family had filed a lawsuit, Mr. Pino would be defending against 4 separate lawsuits. The limitation gives you a vehicle to be able to defend one lawsuit and have all the potential plaintiffs come into that case. It makes these cases easier to litigate. And the other thing about limitation is it's a use it or lose it type remedy. If you don't file that within 6 months of the first written notice of claim, you're barred from filing that lawsuit. So in these type of maritime accidents, it's standard procedure to file a limitation of liability action for this reason. Now, in this case, we didn't end up litigating in the federal case because the 3 other claims were resolved. There was only 1 claim left, and in a situation where there's only 1 claim against the vessel owner, you can't proceed in the federal case. It requires multiple claims. So if you looked at the docket of that case, eventually that case was dismissed voluntarily on Mr. Pino's behalf.
So I don't want to lead you, but I want to make sure the jury understands. If there are 4 passengers making claims in 4 different places, even if they haven't even filed the lawsuit yet, if the Pinos want it all resolved in one forum, federal court, you as a lawyer would need to bring that to the federal court's attention within 6 months?
Objection, it's leading.
I'll try again. Let me start with this. Did Mr. and Mrs. Pino have anything to do with your decision to file that pleading?
No.
Did they even know you filed it?
They were,
Objection calls for speculation.
Excuse me. Yeah, how would they know?
well,
Go ahead, you can tell.
Objection,
No.
I thought the court
Forgive me.
sustained the objection.
Yeah, thank you. No
I'm
speaking
sorry.
objections. I sustain. Next question.
Sure. The decision to file that petition, is that your decision?
I was directed by the insurance company to file that petition. Mr. Pino was made aware of it, but part of the relationship when you're being defended by an insurance company, they have the right to control what litigation is filed, how it's litigated, what money is spent, and how it's resolved. So some of these aspects were outside of Mr. Pino's control.
And that's what I was getting at. Do you file something like this in virtually all the cases where an insurance company is involved?
Well, yes, and specifically in the type of case where you have a marine accident and you're facing multiple claimants.
And ultimately, I think you told us 3 out of the 4 passengers or their families you were able to resolve without ever having to go to court. Fair statement?
Correct.
And with regard to the Puigs, That case also resolved itself, but it wasn't through this federal court motion that we were talking about, correct?
No, if you look at the docket of the federal case, there was no litigation went on there. It was filed because we had to file it by a certain date, and when the other 3 claims were resolved by Mr. Pino and his wife, the need for the federal case went away.
Okay. And then what happened to the case involving the Puig's claims?
So there was some litigation, there was some discovery, which is common in complex situations like this. The case was mediated multiple times, and eventually the legal dispute between the Puig's and the Pino family was resolved, and then it's my understanding they also resolved with the other defendants.
With the paramedics and the other claimants?
Ocean Reef and those other parties.
One moment. Thank you, Mr. Mescalado. Those are all the questions.
Thank you, sir. You're excused.
Thank you, Your Honor.
Judge, may we approach about the next steps?
Sure. Is it all right for me to proceed?
Yes, Judge. We've explained to Mr. Pino his right to testify and his right not to testify, that 2 competing rights, he needs to choose one. And with our advice, he has elected not to testify. I've explained to him that you could choose to testify, that you would colloquy him and explain to him from the court, I believe the same thing I've explained to him, and he's prepared to let you know that that's his decision.
Okay, very good. And I think we've already, I think we saw, I saw you this morning. All right, Mr. Pino, we're just about at that point in the proceedings that, while I think there might be another witness being called in your case, this would be the time that if you wish to testify, you are certainly entitled and permitted to do that. You remember that I had instructed the jury, even during jury selection, that every person who's accused of a crime, any person who's accused of a crime, has an absolute right to remain silent. At no time is the person accused required to make any statements or give any testimony at all. And that applies similarly to you, sir. And a jury cannot hold it against someone for choosing not to testify. Okay? So this is one of the decisions, there's 4 or 5 decisions that are held by the defendant solely. Your lawyer cannot make the decision for you. It's never going to be their decision as to whether or not you testify. But you took time, and I want to make sure you had sufficient time to speak with your attorneys about this important decision. Happy?
Yes, Your Honor, I spoke with my legal team at length, and
Okay, let me keep going. But have you had sufficient time to do that?
I have sufficient time.
All right. And while they will give you their advice, understand that's their advice. Now, sometimes I'll have someone say, well, on the advice of my lawyers, but the real issue is you have to make this decision as your own, knowingly, freely, and voluntarily. While, again, lawyers can give you advice, they can say what they think would be best for you, but it's not their decision. So, have they given you advice based upon their assessment of the evidence that's been presented?
Yes.
All right. And have you made a decision as to whether or not you wish to testify?
Yes, I have made a decision.
Okay. And what is your decision, sir?
I do not wish to testify.
All right. And has anyone forced you into that decision?
Nope.
Threatened you in any way?
No, Your Honor.
Said to you, Mr. Pino, not only are we giving you the advice not to testify, but we're telling you that better not testify or anything along those lines? Okay. All right. So this is your free and voluntary decision.
That is correct.
Do you understand, though, that you do have the right to testify if you wish to do so?
Yes.
Okay, very well. In other words, forced you into this decision, you're making it of your own free will.
That is correct.
All right, very good. So, you can have a seat, that's fine, and I think we're going to, you have your witness, you want to check on your witness? She's here.
So here's where we are. The witness is here.
Okay.
She's the witness who had testified previously who had not had an opportunity to.
The other, right,
So
okay.
there's a recording that she would, I guess, listen to, I guess, authenticate. This-
It's her, it's her on the body worn, right?
That's right.
Okay.
And so
Do you have it?
we do.
Okay,
It may require, because the volume is not very high,
okay.
so that it may be clumsy in terms of how it's presented, because she would need to listen to it, maybe even with headphones
On the TV.
or on the
She
TV.
could come up here on the witness stand with a computer, listen, observe and listen,
Mhm.
and then you could just continue with the questions.
Okay.
Any issue with that, counsel?
Well, yes, Judge, because number one, I don't think that she can be impeached based on her saying, I don't remember. What they can do is try to refresh her recollection with something. I understand that which they want to show her may be in evidence, but she shouldn't have her recollection refreshed in front of the jury in that way. Normally, when up until the time we had all this video evidence, it would be a matter as simple as showing a written statement or a deposition.
Okay, all right.
So I would suggest to the court that they see if they can refresh her recollection outside the presence of the jury, play whatever portion of the video that they want, ask her if it refreshes her memory. Then they could put her on the witness stand and say, did you have an opportunity to view part of your interview with Lieutenant Thompson?
Okay.
I think that would be the way to
Let
handle it.
me ask, did you go back, because you were going to go back and look at the exchange that had taken place, whatever?
We
it
did,
was?
Judge. Mr. Forrest has the exchange of what was said.
Judge, I looked at it. So basically, the defense asked about whether or not the witness saw the defendant on the floor, unconscious and bleeding. Her response was that she was then shown a transcript of her statement to detectives, asked if it refreshed her.
I'm sorry,
Yes.
was that the transcript of this?
Correct. It's the transcript of.
Happened in the-
Yes, Judge, it was that transcript. She was shown that transcript, and she said, I don't remember, but I guess I had to have said that. So to me, they did impeach her, and really, I don't think any extrinsic evidence is necessary, because she said, I had to have said that in front of the jury.
Okay, so this is, I think, how it's best to handle it, all right? You're recalling her, what was she called as a state witness, right? So you're going to call her as a defense witness. You want to address this area, okay? But before I bring the jury in, all right, I'd like her to sit here and, without any conversation, review it, look at it, okay? And we can go through the steps of seeing if, you can ask the question, see if this item refreshes her recollection as to what was said.
That's fine.
Okay?
No objection.
Okay. All right. So do you have headphones or a way to?
We could put on the TV, maybe.
I think we put on the TV, that might do the trick.
Okay, that'll be fine.
Shall I get the witness?
Yes, so let's go ahead and bring the witness in first, and then we'll bring the jury. And then, counsel, you're calling the witness anyway, so you can,
I couldn't hear you, I'm sorry.
you're calling the witness anyway, so you can ask whatever questions.
Yeah, and actually, well, here she is. Maybe we can resolve it even without it, because we sent her the recording over the weekend. Maybe she's already listened to it. So we can find out during this colloquy right now.
Please, thank you.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Come and have a seat over here. what you require.
Okay, and good afternoon, Ms. McRae.
Good afternoon.
When you were here last time, Ms. Gomez had asked you some questions about the statement you gave to Lieutenant Thompson in April of 2023. A recorded statement. Do you remember having given this statement to Lieutenant Thompson?
Yes, I don't remember the date, but yes.
Okay. And at that time, do you recall telling Lieutenant Thompson when he asked you about where George Pino was on the boat after the impact, that you had said, he was on my right, like on the floor, yeah, and he was bleeding, he like unconscious, and then the boat was like sinking, so I jumped from my right, like I jumped to my right. I don't know, I didn't see George after. Like I saw him, like when I jumped, he was still on the floor.
Yes.
Okay. You recall telling that to Lieutenant Thompson?
Yes, after listening to the recording.
I'm sorry?
Yes, my memory was refreshed after listening to the recording.
And what you told Lieutenant Thompson, was it true that you saw Mr. Pino bleeding, unconscious on the floor?
Yes.
Okay. Thank you very much. So,
Should I have the witness step outside now?
I don't think it's necessary. I would then we don't need the recording if the witness is prepared to just testify to that. Those three questions will be done.
All right, and I don't, okay, you're calling your witness.
That's right.
In front of the jury.
That's
All
right.
That's fine, Judge.
That's it. Okay. So, the jury's what, down the hall? Okay.
Judge, before we proceed, may I just ask the witness one last question while we're before the jury gets here,
Sure.
so that we clarify. Last time you were here, you were asked some questions about who told you to jump from the boat. Now, do you have a recollection of who it was that told you to jump?
George?
Before he was unconscious, or after he was unconscious, or when?
He told me to jump after he was unconscious.
When he regained consciousness?
He was in the water and told me to jump, so I'm guessing after he regained consciousness.
That's your best recollection?
Yes.
Okay.
All right, so if I could, please, I'm going to ask the witness to just sit right on the benches outside. We're going to call you back in when the jury is coming to courtroom, okay? All right, and just don't say anything as the jury is walking by, okay?
Okay.
All right, very good. So Renee will go up and bring the jury, and then we can proceed. And you'll call the witness as your next witness, okay?
Wait for the jury? Yeah. Your Honor, wait for the court order. After the last witness, I would have a motion to make post-trial, a post-resting motion. How do you want to handle that before the state's rebuttal case? If they have one, I don't know if they have one.
If you don't mind me asking, will this be the last witness?
Right,
Okay.
yes.
I would say, Judge,
I'm going to probably ask the jury just to step into the jury room for purposes of you making any, after you rest. Well, actually, then it would be, we would go through to the state's rebuttal. And at that point, would be your additional motion. Do you have a rebuttal with this?
I do, Judge, but I don't want to drag things out, but rather than litigating what I presume will be the second JOA motion.
I'll do that today, though.
Oh, 100%, but like if the judge would give us like 20 minutes or so in between the defense resting and us litigating the case, and, you know, then the state putting on its rebuttal case, that would be great.
Okay, but you haven't agreed with this, right?
Yeah, we're going to finish today.
Oh, I just wanted to...
Yeah, we'll be done
and
today.
that witness is available.
Correct.
Okay, all right, that's fine.
And so we're going to rest after this witness with the understanding that we've offered the Thompson, Scolavino statements, and the court has excluded them.
Correct, but you're going to mark...
They're marked.
They're marked already,
Yeah,
so we'll put on the record what they're marked as is for identification.
Doesn't need to be in front of the jury, obviously.
No, do that now, actually. Because which of course, will walk in
There it
as soon as you start.
834. That's the FOIC report.
Correct.
So at this time, we will formally offer Defense Exhibit A34 for identification. That would be the incident report, just those statements that we contend are admissions by the party opponent that alcohol did not contribute to the...
That we addressed during our pre-trial litigation?
Yes, Your Honor.
Okay, and that's marked already as A34?
Yes,
Yes.
Judge.
Okay, so marked for identification is A34. My ruling remains the same, but the record is clear. Stay right there.
And likewise, the admission by ASA Ruben Scolavino that the case did not support a recklessness charge.
And that's in the form of...
That would have been within the deposition testimony of Lieutenant Thompson.
Did you excerpt that? How was that?
Yeah, I can provide that. The printed excerpt?
Because you're gonna make a copy of it, I presume, as part of the record, and it'll be marked for identification.
Shall we mark it as 835? Is that?
It's going to be 8:38.
838, excuse me. We'll mark it as 838, and we'll tender it to the court after the jury steps out. Does that help?
Okay, because the other, I guess the incident report was already previously marked for identification. We're jumping from 34 to 38.
There must be something in between.
Yes, there are things in between, Judge. We jump into the 8:38.
No problem.
Remember the whole depot? Just that portion.
So you need the first page of the deposition so we can identify it.
Okay.
And I would assume you have other copies, but
Yes.
whatever the excerpt portion is, we'll mark that as 838 for identification as part of the record. But we have to make sure, understand, these are not exhibits that are going back to the jury. My ruling remains the same.
Understood. Yes, and Ms. Gomez is going to do the examination.
I can just mark this after. It's not.
We'll do that. Okay. Let's go ahead and do the jury.
The defense calls Carolina Monterrey.
All right. Would you please step forward, face the clerk, and be sworn?
You solemnly swear or affirm testimony about to give the truth, the whole truth, and nothing but the truth?
Yes.
Tomorrow, we'll have a seat. Thank you. Remember to keep your voice up, okay? Thank you.
Good afternoon, Ms. Monterrey. Can you please introduce yourself again one more time to the jury?
Hi, I'm Carolina Monterrey.
Ms. Monterrey, have you had an opportunity to review a video recording of your interview with an officer following the accident?
Yes.
And having reviewed that video, did you refresh your recollection that following the accident, after the impact, you in fact did see Mr. Pino on the floor, unconscious, bleeding?
Yes.
You recall having witnessed that right after the accident?
Yes.
Okay, that's it. No further questions, Your Honor.
Okay. Any questions?
No,
Very well. Witness is excused.
Judge, we have no additional witnesses. Mr. Pino's case rests.
Thank you. Okay. All right. It's going to seem a little strange, but I'm going to ask you to put your notepads down. Did you have a snack yet? You did. Good. Would you please, if you would, step into the jury room. Please do not speak about the case. All right? We're going to handle a few matters with the attorneys, and then I'll have you come back in. All right? Thank you. Watch your step as you step in. Okay, everyone be seated. Let me just give you a couple of minutes to gather your thoughts, and then I'll go ahead and take the motions, okay?
So, Your Honor, we're here again moving for a judgment of acquittal on both counts. We understand that the standard for Your Honor's review is taking the evidence in the light most favorable to the state. Could a rational jury find that the state has proven all the elements beyond a reasonable doubt? And so I'm going to try to read my audience, that being you. You've already ruled, at least through the state's case, that there was enough evidence. And so what I'm going to do is readopt the arguments I make, but ask you to focus now just on the culpable negligence manslaughter charge, because that is the more serious charge. Of course, both of them are very serious. As the prosecutor alerted you, the guideline sentences for vessel homicide, 9 years in prison. The guidelines for culpable negligence, I think, is 11 years. So we're talking about two very serious charges. But in terms of the government or state's burden of proof, there is a higher mens rea element with regard to culpable negligence. And so even if the court is going to allow the recklessness charge to go to the jury, and I've argued to you why that shouldn't happen, because there is no evidence of a course of conduct by Mr. Pino to drive in a reckless manner. For the state to establish culpable negligence, there needs to be, apparently under McCreary, recklessness plus. Something beyond just being reckless. It has to be something even more serious. And to be clear, even if you were to grant the motion just as to the manslaughter charge, we would still be facing this recklessness charge. And I'm inviting the court to give greater consideration to that, if for no other reason that to try to get a jury to understand the difference between the two. I think you're going to find, if you haven't already gone through the nuances of the jury instructions, it is going to be a nearly impossible task to explain to the jury the difference between the two, because the language for culpable negligence incorporates the word reckless. And so it is particularly confusing. And so we're quite confident in our position that mere elision coupled with catastrophic injuries does not establish recklessness. The evidence presented through Mr. Albert, the lieutenant who served as the government's expert, I think the takeaway from his testimony, the government's theory when we brought him back, is that Mr. Pino simply did not see the marker, whether it was because the passengers were seated in the designated bow seats and raising their arms and distracting Mr. Pino, approaching a marker that is 5 feet lower to the water level than the other markers in the channel at a time, high tide, when that marker was at 6 feet above the water line, and the passenger seated on the bow would necessarily have obstructed the view of that marker. The combination of those things, under Mr. Albert's theory, would have required that Mr. Pino take some action to have the passengers clear the way for him to see, and that his failure to do that was the cause of the accident. That is the takeaway from Mr. Albert's testimony, all of which adds up to, at best for the state, ordinary negligence. Failure of Mr. Pino to create a proper ability to see this marker that's lower in the water at high tide. It does not evidence some course of recklessness, given that Mr. Pino had navigated that channel that day, both going up to Billy's Point and returning back. His operation of the vessel put no one in danger. He was able to navigate through that channel, coming back at the speeds that the state contends were, in their view, excessive, but apparently not so, because you've heard it already from other witnesses, including law enforcement officers, including David Rodriguez, who was traveling upwards of 55, if not 80 miles an hour in Biscayne Bay. And so it was ideal conditions to operate a vessel at the speed at which Mr. Pino was operating the vessel. So all that the state has as a theory is that Mr. Pino, looking through a windshield with 7 girls sitting in a designated bow seating, some of whom were celebrating the birthday by waving their hands and singing, obstructed Mr. Pino's view. He did not see the marker as it approached in the last 9 seconds. There was plenty of time, if he had seen the marker, according to Agent Albert or Lieutenant Albert, to avoid the marker. But of course, if he didn't see it, that explains why he hit it. And I say to the court, if you think that maybe there's recklessness there, we say not, based on all the cases we've cited, it certainly doesn't then elevate to culpable negligence. And so at a minimum, Judge, if for no other reason than to give the jury a simple question to answer, if they're going to have to decide this case because Your Honor is not prepared to grant a judgment of acquittal as to both charges, we submit that at a minimum, preserving our issues for appeal as to both counts, we suggest to you that the immediate option would be to grant a judgment of acquittal as to the manslaughter count. Thank you, Judge.
Thank you, sir. State?
One moment, please, Judge.
So start off with, if you can answer the
Yes.
issues of fact in dispute for why the case, both counts should go to the jury at this point. And while my standard of reviewing the second motion for judgment is clear, generally, by the way, we would have this argument post any rebuttal case by the state. So I'm going to take the arguments here and consider them renewed, because I understand the state is going to call the rebuttal witness. Go ahead, State.
Your Honor, at this point, even with the defense having presented a case, this is not a scenario where a second judgment of acquittal should be granted. Number one, the claim that the defendant's view of the channel marker was obscured by girls standing and singing and dancing, I would point the court to the cross-examination of Miss Porter-Carrero, who testified that, yes, they were dancing and singing and all of that at some point on the boat, but I asked her very specifically, in the moments leading up to the crash, were people standing up and singing? And of course she said no, because it's illogical to believe that people are standing up and singing and dancing while a vessel is traveling just shy of 50 miles per hour through the water. Moreover, it is...
Well, there's a conflict in the testimony, right?
I would submit no.
Let me make it clear. No one has contended that anybody was standing. It was simply that they were raising their hands dancing
All right,
in their seats.
there's conflict because maybe one or two witnesses testified to something about moving their arms around, but in terms of how much of a view could or could not be obstructed, isn't there a question for the jury?
No, because the only witness who said anything about that was Ms. Porter-Carrero, and I asked her, was that going on in the moments before the crash happened, and she said no. So from the state's perspective, the defense established that at one point the girls were doing that, but not at the time in the moments leading up to the crash itself. So that's number one. Number two, there's no, even if hypothetically there were arms waving, the seats, they're meant to be seats. It defies logic to think that this vessel, which the court had the opportunity to see, the jurors had the opportunity to see, that young women seated on those seats, just the mere waving of their arms, none of them are like, mixed martial arts fighters or something. There's no way that their arms would have obscured the view of that channel marker. Beyond that, the defendant himself confirms that he saw the channel marker when he's at Elliott Key and talking with Lieutenant Thompson about how the crash happened. He talks about the fact that we were approaching the last channel marker. So clearly he knew it was there. Clearly his view was not obscured by these young women's arms. Now his view may have been obscured because I don't know, he closed his eyes for 9 seconds, he was looking at something else, he was looking down at a screen. I don't know what he was doing, but whatever it was he was doing, he did not see this for at least 9 seconds, which is a really long time when you're going that fast, or he did see it and just thought, I'm not going to do anything. Either way, when a hazard that you know exists is coming up rapidly to you and you have the ability to see it, if we just agreed in criminal courts that, well, as long as the person didn't see the hazard, then it's just negligence, that just does not make sense. And the law is supposed to make sense.
Well, so counsel raised the argument, well, even if there's evidence of recklessness, certainly there's not the greater amount of evidence to rise to culpable negligence. Can you answer that?
Well, I would submit to the court, as I did in our first JOA motion, had there not been all these additional people on the vessel, had there not been all the alcohol that we know was consumed by the defendant as well as the girls that were on the boat, if under that set of circumstances, and if he wasn't even traveling as fast as he was, if he, pursuant to the GPS data that we have, ran headlong into that channel marker when he had ample time to avoid it, I would agree this would just be vessel homicide. But this is reckless plus, because he did have 12 minors on the boat, many of whom had been consuming alcohol. He himself admits that he had been consuming alcohol. Now, he claims it was 2 beers. The jury gets to apply to his statements the same type of evaluation as they would to anybody else. Did that witness, or did his statements come from a person that might have, I don't know, a motive not to tell the truth? If this defendant was so brain damaged that he's making up, claims of other boats that now the defense says, yes, they weren't there, then maybe also he forgot how many beers he actually had. Or the converse could be true. He deliberately knew there was no other vessel, but he wanted to blame someone else for his actions, and he knew that he'd had more alcohol than 2 beers, but he wanted to undermine his liability, culpability, what have you. So this is not just recklessness. This is recklessness plus, because not only were there all those minors on the vessel, but even if hypothetically each of them only weighed 100 pounds, you're talking about an extra 1,000 pounds on the bow of that vessel, which, as the court has already heard, is going to make the vessel more difficult to navigate, especially given that boats are steered not from the front, but from behind. Obviously, boats don't have brakes, but we have so much more here than just a man who runs into a channel. We have a man with alcohol on board, with minors on board, with many minors on board, who also has a long-standing knowledge of that channel and where that channel marker is. So in terms of culpable negligence, I think we have absolutely established culpable negligence, because it is such an entire want of care as to almost be a deliberate disregard for the safety of those that were on his vessel.
How does the GPS at all play into this in terms of how the GPS was set or not set?
Set or not set?
In terms of the, assisting Mr. Pino, if at all, in the navigation. What was the only evidence is the GPS, right?
Right.
And there
Well,
was,
it's not the only evidence, but in terms of the track of the vessel prior to impact,
that's what I'm trying to-
absolutely.
Okay. But there was a change in that.
The only change in the vessel's path right before impact was when he went further 5 degrees to port, which put him right on that path, which is why this is charged as manslaughter, not only on the culpable negligence theory, but also the state has pled that by intentional act he has committed manslaughter, because he may not have intended the death, which of course the jury instructions state, but he was the one deciding to go full throttle. He was the one deciding where to steer that ship. And he steered it, we know, 9 seconds prior to impact, right into the path that was going to force him to hit the channel marker. I'm sorry?
Also, it stayed on the original path without that change that was effectuated by the operator.
Yes.
Okay, then the marker would not have been hit.
I'm sorry, I didn't hear the first
marker
part.
would not have been hit.
No, I'm sorry, if the court could just back up. The premise,
The operator maneuvers the vessel seconds before.
9
seconds before.
9 seconds.
Prior to the maneuver, the vessel, if it had continued on the track without the interaction of the operator, would have not hit the marker.
Of course.
That's
Yes. It was his action that put him on that collision course, which I don't want to leave out the fact that, yes, for those 9 seconds, that channel marker was visible, but it was visible even prior to that.
Okay, let me ask this. You had pled in alternative theories under the manslaughter.
Yes.
So explain to me how, in terms of culpable negligence, how, if at all, or what the state would have to prove if you are proceeding under the alternate theory in culpable negligence.
Culpable negligence being the alternate or the intentional act?
There's two theories.
Right.
So if the state proceeds under the intentional act,
yes,
there's the evidence of the claimed intentional act would be that change in direction.
Yes.
Okay. So culpable negligence would not be something that would need to be established by the state under the alternate theory as charged through the manslaughter.
Right. It's kind of like kidnapping. You can charge somebody with that they've moved someone with an intent to harm or terrorize them, or that they moved them with an intent to commit another felony. Either theory can work. Here, there are two theories for manslaughter. Manslaughter by intentional act, by the act of him simply choosing to go on a path that put him on a collision course, and or manslaughter by culpable negligence, because the way that he was operating that vessel was so grossly and flagrantly dangerous as to almost invite a proof that it was like almost a conscious disregard for the safety of others. You know, quoting
and
the
that's
language.
based on more than speed alone?
Of course. There's never speed alone. And speed alone, although I know the defense likes to, chant that jingo, Luzardo in the 3rd DCA specifically said we reject the idea that speed alone is not enough. The 3rd DCA said speed alone is not enough until it is. But there's never only speed. There's speed plus the location, plus the weather conditions, plus, there are so many different variables.
Well, the nature of this channel.
The nature of the channel. It's a narrow
Would you
channel.
consider that in terms of the prior knowledge of Mr. Pino, would you consider that something relevant, meaning the narrowing of the channel and understanding, how the channel moves?
Yes, because again, when we look at the way that part of Biscayne Bay, when it filters into where Card Sound is, there are only so many ways that vessels can traverse between those two bodies of water. And so by the defendant choosing to operate on the wrong side of the channel, maybe in and of itself doesn't create a danger, but if a person drives on the wrong side of the road, just because they see nobody's coming in the opposite path, well, the problem is with the nature of traffic, it's always moving. And we know that there were a lot of vessels around because within minutes after this crash, Good Samaritans are coming to the scene.
And so the totality of your position is that given the totality of the circumstances, the jury could find, a reasonable juror could find, a reasonable juror could find that the elements of the manslaughter, even under culpable negligence, are met. I don't want to put words in your mouth. I want to understand if that's the argument.
That is the argument, and I haven't had the benefit of sitting down and going through all the evidence like I will for the closing argument, but I think that all the highlights from the state's case in chief that the court, and I understand it's different standards, but all of that evidence that came in, none of it was undercut or undermined by the defense case in this matter.
Okay. Just one question from the defense, and then I'll be, I have for the defense. I'll allow you 2 minutes of rebuttal, but my question is, as the state in charge, the manslaughter under alternate theories, can you respond to the intentional act?
Of course.
Yes.
No one's claiming he intended to strike the marker. That's not the state's theory.
The intentional act of shifting the
Course, changing course.
Changing course.
Yeah. So the boat was on a path to clear channel marker 15.
Right.
Right? And so the GPS track shows the boat starts heading, changes heading, which the state says puts it on a collision course.
Okay.
So no one's denying that Mr. Pino was in control of the vessel. The state's theory is he's in control of the vessel, and the state's not contending that he was intending to ally with the marker. Because the decedent had no evidence of blood alcohol. So there's no claim that the decedent was intoxicated. So that's a, that's a red herring. There were other girls on the boat who were intoxicated. No evidence that the decedent was.
Okay, well, I want you to come back to focus on, so under the alternate theory of manslaughter, intentional act, okay.
The intentional act would have to be he intended to hit the marker, which no one says he did. He intended to operate the vessel. He voluntarily operated the vessel, but it was not his intent to hit the marker. The state's already told you repeatedly if that was his intent, he'd be charged with murder.
But what the state's position is, I think I understood, the intention to actually change course, even the slightest change of course, which then,
I think I understand your point. He changes course to the south. Had he continued changing further south, he would have avoided the marker.
Okay.
Had he left the course as it was, he would have avoided the marker.
Okay.
So he's driving along, and the state's theory is the vessel in Mr. Pino's command starts heading further south, and the vessel is now on a collision course, according to the state.
Okay.
But it wasn't Mr. Pino's intention to aim at the marker. There's no evidence that was his intention. So when we talk about an intentional act that's reckless, yes, I agree. If it was his intention to hit the marker, guilty. But that wasn't his intention. No one says it was. There's no evidence that was his intention. That's the point. See if there's anything else I wanted to say. Oh, and then the state's reliance on Mr. Pino having consumed some alcohol throughout that day isn't sufficient under the Jackson case that we've cited, that has, when we submitted it to you in the form of the proposed jury instructions. And so, since there's no evidence of impairment, no evidence of intoxication, what we're left with is nothing that could elevate this from, if you find reckless to be sufficient for a jury to consider, taking it to the next level of manslaughter and culpable negligence.
Consider the argument of counsel on the second motion for judgment of acquittal. As to count one, the court is going to maintain my position at this point that there is sufficient evidence to go to the jury on manslaughter, and the motion is denied. As to the vessel homicide, there is sufficient evidence to go to the jury that the operation was vessel homicide operating in a reckless manner, so the motion is denied as to both counts. On the defense second motion for judgment of acquittal, and again, I'm going to consider this as the argument you would make and present post a rebuttal witness, okay? Because generally I'll take that after the rebuttal, but I don't want timing-wise keep the witness too long or keep the jury too long.
And may we inquire potential objection?
Absolutely. It's the state's intention to call Rudy Puig, the father of Katy Puig, not to get into anything other than Katy, prior to this crash, was healthy, was active, was an athlete, and that post-crash, she now is bound to a wheelchair and needs 24/7 medical care. And the reason why I believe this is rebuttal, Judge, is because on redirect, after I had crossed Mr. Mescalato about simply some pleadings that were filed, the defense brought out information which, frankly, I'm not sure if it even violated any kind of confidentiality agreement. I'm not involved with any of that. But the fact that Mr. Mescalato volunteered things like everybody else settled except for the Puigs, I think the fact that their daughter was subjected to a unique level of injury that requires a significant amount of money. I'm not getting into the terms of the money, but simply to establish that the injuries that Ms. Puig suffered were catastrophic in nature. It will be no more than just a couple of sentences, but I think it leaves out there the way that Mr. Mescalato volunteered information to the jury, the thought that perhaps the Puigs were just, looking for money or something, for their golden ticket.
I think somewhat unreasonable. We started to go down a path with the additional questions about the Puig litigation that I'm going to allow very limited. I imagine this will be over defense objection. I don't want to speak for you. And I think in the questions in redirect, I didn't particularly expect it, but we got down a path. But again, this is not a feature of the case.
Absolutely not, Judge.
And I would, if the defense requested any kind of instruction, or I may be instructing the jury, I'd like to address that now, because we're, again, in this matter, in the criminal matter, the alleged victim is only Ms. Hernandez, while there were other individuals who were certainly alleged victims. That's a part of the civil, whatever the civil matters were, and I don't want to confuse the jury at all. I want to make it clear that this is the only individual who is the claimed victim in this criminal matter.
I've spoken with Mr. Puig. He understands that this is going to be very, very narrowly tailored questions. The whole thing should not last more than a couple of minutes max. I'm not going to make Ms. Puig a feature of this trial in any way, shape, or form, and I haven't at any point in this trial.
We permitted it. All right, what would you like to say, counsel?
So obviously it's over objection, and I assume Your Honor has ruled. I'm struggling to identify, since the state had, on cross-examination of Mr. Mescalato, brought out the business about the exoneration of liability. I think my questions were focused on what that means, and that it consolidated all the cases. It would consolidate all of the cases. That's exactly what he said.
I think it went a little bit beyond that, maybe not an exact response to your questions, although I think you were trying to narrow in the questions. Some of the responses was not clear, I don't think, and I don't see it inappropriate to be clear to the jury that there were different levels of injuries, and basically leave it at that.
Yes.
You know?
So could the court, of course, I object, but I understand the court rules, and I'd like to understand then what the court is allowing so that I can...
I don't want to go down that path of the, tear the heartstring on
Judge, why don't I do this?
jurors, and it's very, very difficult.
Why don't I just tell the court, spoiler alert, this is my direct examination. What is your name? How old are you? Where do you work? Do you have any children? How many? I then will ask him about his daughter Katy, how old she is now. I will ask if she went to a birthday celebration weekend at Ocean Reef Club for Ceci Pino's birthday over Labor Day weekend of 2022, that his family knew the Pino family, and that when she went to go to Ocean Reef Club for that party, at that time, she was healthy, she was active, a good student, and an athlete, and that after the boat crash, she is very different. She is now bound to a wheelchair. She requires 24/7 care. She has to get therapy for speech, and that this kind of medical care is expensive. That's it.
So my recollection is in the government, in the state's direct case, they asked several witnesses over objection about Ms. Katy Puig and how she's not in the same condition now that she was before. The court had allowed that already over objection. This is now trying to add...
We're getting into a lot of, even though it's a lot of much more extensive injuries, has had extensive injuries to the point where she has continued care and will continue to need care for the remainder of her life. I think that is all over defense objection that I'm going to allow.
Well, that she's wheelchair bound and that she will need medical care for the rest of her life.
I think, Judge, you've established, if you think it's relevant over our objection that she requires continued care. I think if that's what you're trying to accomplish, going into the details becomes unnecessarily inflammatory.
That's not detailed. We could go into a host of other issues that Ms. Puig needs, but the fact that she is now wheelchair bound and requires 24/7 care is the most de minimis way to describe what has happened to what once was someone that was able to go on this journey.
She was able to go on the trip as a healthy 17-year-old, and because of what transpired, her life has changed to the point where she will need continuous care for the rest of her life, continuous medical care for the rest of her life. And counsel, let me tell you why I'm comfortable with that, okay? Is because the implication perhaps was that there was some unreasonable aspect of the police remaining involved in litigation with the Pinos. I think that covers that issue.
Okay, Judge, that's fine. Let me just make sure that I'm understanding. So Mr. Puig will be able to say now she has injuries that will require care for the rest of her life.
Correct.
Okay.
All right, over defense objection, okay? I think that that's reasonable given Mr. Mescalato's responses that might have gone somewhat beyond the scope of your questions, but he perhaps left some type of impression that I think is fair to allow the state to clear up with the jury focusing again on, this is a criminal matter. This is not a matter involving a civil, this kind of civil litigation.
And so if you're going to allow that, then I would propose as a way to communicate to the jury that a stipulation to that effect.
I remind everyone that the alleged victim in this case is Ms. Fernandez, and this is a criminal matter.
What I mean to say is, I understand that the state would prefer to call the father so that the jury can see the father, but given that he is not the father of the technical victim of this case, if the court is going to allow the fact of the required continued care for life, it can come from a stipulation of fact rather than creating even more theater in the rebuttal case.
Judge, I can assure the court that Mr. Puig will not cry anywhere near as much as Mrs. Pino did.
That's fine, okay. We're not going to do that. I don't think there'll be anything more. I'm not going to, you don't need to do this through a stipulation. You have the witness here. It's over defense objection for the jury.
Judge, I do also plan on calling Mr. Fernandez as a final rebuttal witness.
All right, everyone. If you want to please be seated. All right, State.
Thank you, Your Honor. In rebuttal, the state will first call Rudy Puig.
So would you please step forward, face the clerk, raise your right hand and be sworn.
Do you solemnly swear affirm testimony about to give the truth, the whole truth, and nothing but the truth?
I do.
Take a seat.
Now we're going to see the witness.
approach us 1 second, please? Sorry to the jury.
Good afternoon. Can you please tell the jurors your name?
My name is Rudy Puig,
How do you spell your last name?
P like in Paul, UIG.
Okay. As you probably know, this courtroom is large. The microphone, for some reason, was placed over there when the jurors are there.
Okay.
So please try to keep your voice up, okay?
Yes, ma'am.
How old are you?
I'm 54.
Do you work?
Yes.
What kind of work do you do?
I'm a director of business for a security company.
Okay. Do you have any children?
Yes, 3 of them.
Okay. What's your oldest child's name?
Amanda,
And how old is she?
she's 26.
What's your second oldest child?
Rudy Jr., he's 25.
And your third child?
Katy Puig, who's now 21.
Did your daughter, Katy Puig, go to Ocean Reef Club the weekend of Labor Day in 2022 for a birthday party for Ceci Pino, the daughter?
Yes, ma'am.
Okay. Does your family know the Pino family?
Yes, we do.
And do you, in fact, know George Pino?
I do.
Do you see him in court today?
Yes.
What's he wearing, just for the record?
He's wearing a blue suit with a light blue tie.
For the record.
Stipulate.
When your daughter, Katy, went to go to that birthday party, was she an athlete?
She was an incredible athlete.
Did she go to school?
Yes, she did.
Was she healthy?
Yes, she was.
Now, do you get contacted on the evening of September 4th, 2022 by a man named Hillary Candela?
Yes.
And you learned that your daughter was involved in a boat crash?
Yes.
Is your daughter in the same condition now that she was when she went to Ocean Reef Club?
No, she's not.
Does she now need 24/7 medical care?
Yes.
And is that expensive?
Very expensive.
No other questions?
Thank you. Any questions?
No questions.
All right, thank you so much, sir.
Thank you.
State will call Andres Fernandez. One moment, Judge.
Place it right now. Do you solemnly swear or affirm to tell the truth and whole truth and nothing but the truth?
Yes, I do.
Take a seat. Good afternoon. Just for the record, can you please introduce yourself or reintroduce yourself?
Andres Fernandez.
Mr. Fernandez, were you here in the courtroom when Mrs. Pino, the defendant's wife, testified?
Yes, I was.
Is it the case that growing up you and she were very close?
Very close.
And is it the case that you did attend her wedding to George Pino, the defendant in this case?
Yes, I did.
Is it the case that in your early years of marriage and when your daughter was first born, your two families, the Pinos and your family, were very close?
Yes.
Did the girls go to the same elementary school?
Yes, they went to school together.
At some point, does your daughter wind up going to a different high school than the defendant's daughter goes to?
They actually, in middle school, they began going to different schools.
Even though they were going to different schools, were they still friends with each other?
Absolutely.
But as time has gone by and the girls have gotten older, is your family kind of doing its own thing and the Pino family doing its own thing?
Yes, our relationship began to distance at that point.
Okay. On the actual weekend, when your daughter Lucy went to Ocean Reef Club for the birthday celebration for the defendant's daughter, little Ceci, did you have plans to attend a dinner that was the night before the crash happened with
No.
the Pinos?
No,
Did you have plans to go the night that the crash happened to that party at The Point that was planned for the girls?
no.
In fact, what was your plan for that night?
I was going to watch the football game with my father.
Okay. Did you have any plans to go out to the sandbar on Sunday, September 4th of 2022?
No,
But you did.
but I did
And why did you go?
because Lucy asked me to go.
Okay, no other questions.
Any questions?
Hello again, Mr. Fernandez.
Hello.
Do you recall that you sent Mr. Pino a text message earlier before the sandbar event, actually telling him you planned to go to the sandbar?
No, I actually sent him a text message the week before, and I had, established communications with him that we were also going to be down there that weekend. But talking about specifically going on Sunday, I don't think I made any concrete plans.
If you just hold on 1 second. Yeah. May I approach the witness to see if something refreshes his recollection?
Yes.
Does that refresh your recollection that you were actually planning to go to the sandbar on Sunday after you played golf, that you'd be then tailgating? Let me start again. You recall writing a text message to Mr.
Objection,
Pino?
this is hearsay.
Rephrase your question.
Yeah. Did you send a text message to Mr. Pino that said, Billy's on Sunday for me for sure after golf. I'll be tailgating at Billy's for the FSU game on Sunday night. I'm not arriving till Saturday because of Columbus's beach bash party on Friday night that all the kids are going to.
Correct. I had sent, this exchange was the week prior to that weekend.
Okay. So, and that was really the last
Yes.
text message?
Yes.
Okay. So the week prior to that Sunday, does that refresh your recollection that you had communicated to Mr. Pino that it was your plan, at least then, to go to Billy's Point on Sunday after the golf game?
It was my plan then.
Okay. Thank you.
Anything else?
By the time Sunday afternoon of September 4th, 2022 came around, why did you no longer plan to go out to the sandbar?
Because I had, as I said in my earlier testimony, that it had gotten late that day. We were already running late, and I had plans with my father to watch the football game. So our intention was to no longer go out to Billy's Point.
No other questions. Your Honor, the state of Florida rests its case.
All right. Can I see the papers? I'll be the court reporter. 20 seconds over. All right, ladies and gentlemen, the state and the defense have rested. The next part of the proceedings will be the closing arguments, but we are not going to begin the closing arguments now. As I indicated to you, we do not have court on Friday. Courts are closed, it's a holiday. And so because of that, I have to make sure that once the closing arguments have concluded, that I have sufficient time to then instruct you on the law and then have you begin your deliberations. I'm not comfortable doing all of that tomorrow with you, all right? Because again, then we would have Friday, Saturday, and Sunday with no court. So, we have agreed that we're going to have tomorrow off. Friday will be off anyway. You're going to return Monday at 10 a.m. and we will begin closing arguments on Monday, the 22nd, at 10 a.m. And hopefully you should get the case then, the jury should get the case by mid-afternoon, and then you can begin your deliberations on Monday. All right? So that's the plan. So you'll be returning on Monday to the jury room, 10 o'clock. Please put your envelopes inside your notebooks. I mean, your notebooks inside your envelopes. That's what I wanted to say. Do not discuss this case, please, with anyone. Certainly not with each other or anyone else. Please don't do any research or independent investigation to gather any information outside of this courtroom. That is not evidence. You have all the evidence, okay? And you cannot rely on anything other than the evidence and the law I will instruct you on to ultimately reach your decision. If you see any of us at any point outside the courtroom, we will continue to ignore you. Keep your juror badges well displayed, and I'm instructing everyone also, please stay clear of anyone wearing a juror badge, even if you do not recognize them as one of our jurors. Okay? All right, so we'll let you go at this time. Have a restful and pleasant few days. You should go about your business in terms of work responsibilities or any other obligations that you have when you're not here working. Okay? Very good. Thank you. All right. Please have a seat.
Can I just have this marked? This is the
Was that
thing before I said I was going to wait on the
yes,
transcript.
thank you. And that would be 38, I think.
Yes,
right?
Judge, 838.
Okay, thank you.
Modified education.
Yes, Judge.
And we have to print the exhibit we showed Mr. Fernandez for that
Yes.
as well. But that'll be later.
That's fine. All right, so our plan is, I think, I'd like to get a good, solid working copy of our jury instructions before the weekend. So I would propose that, I don't know what your day looks like tomorrow, but it would just be for our purposes, it would be regular, jury won't be here. I was thinking maybe 1 o'clock, and have you here, and we'll work on the instructions. I have your special requested instructions, so I think our focus is going to be on the 2 charges.
Would the court like us to meet here or in 4-6?
You're going to pick up all your items anyway.
Yeah.
So 4-6 is fine. You can use my regular courtroom. Because again, we're not going to have a jury here. So we'll just be addressing the jury instructions, and I can't think of anything else right now, but you'll certainly let me know tomorrow if there was anything else.
Judge, if this courtroom is available, given that it's more spacious for the lawyers, is it possible to
I'm
stay
just
here?
realizing you have a lot of people there.
And
So,
stuff.
all right. It will be available.
Thank you. So we can meet here?
So I'll see you all here at 1 o'clock tomorrow, okay?
Judge,
Ma'am? Counsel? Counsel?
we just want to address one issue with the court before we break today. So, there was an incident yesterday during the state's cross-examination of Mrs. Pino that I would like to just alert the court. Ms. Adams was towards the witness stand and she was facing Mr. Pino, and I personally observed it myself, you know, something of a stare down followed by Ms. Adams rolling her eyes at Mr. Pino. After that, I also know that it was captured by Court TV. It was published. I've received a video from somebody that shows that part. I just want to raise it to the court's attention. I don't think we're going to have any of those instances anymore because we won't be in front of the jury. But considering that this is now the second instance, I know that, Your Honor, you know, we were in court last Friday. Something happened between them, and I just want to alert the court one more time and just try to avoid any kind of situation like this moving forward. And that's all, Your Honor.
Okay. Let me see you all at sidebar because I've made some observations myself, and I'm going to put it on the record at sidebar with the court reporter. Thank you. Several matters that I need to address in my own observations. So I think that, and I'm hopeful that I've cleared up all of those matters, and we'll be able to proceed without any further disruption along these lines. Okay? Other than that, I don't think there's anything else for us today. I'll see you all tomorrow, 1 o'clock. I'll see you. Thank you.